session. All those having business before the court are here. The Honorable Judge Judge Simpson.
And good morning, everyone.
Good morning.
Court does call Oak Tree Residential versus Brittany Hill.
Good morning, Ellis Fritton for the plaintiff, Your Honor.
Ms. Hill.
This is Brittany Hill.
Oh, got her. She's not labeled.
Your name, ma'am? Because you're
Brittany
not
Hill.
labeled. All right. What is plaintiff's claim in this case?
Total, including costs, is $4,073.40, $4,073.40.
All right. Ma'am, how were you intending on getting this paid?
I actually filled out an application to get rental assistance to DHS and the Hawk.
Okay, and also, so you filled out an SCR?
Yes, sir.
All right. In your packet that was sent to you, there's what's called a rental assistance form. You'll need to fill that out, put your tracking number on it, and file it with the court by next Wednesday. You understand that?
Next Wednesday, yes, sir.
And how many people are in your house?
3.
All right, just so that you know, in SCR, if they give you the maximum amount, it's only going to be about $620.
Correct.
Okay. So I'll grant an adjournment for that process to take place. Is there anything you could pay before next week?
I have a check coming next Tuesday. I planned on paying some, and then I get our survivor benefits from Social Security on the 3rd Wednesday. I also plan on paying that whole check to them too.
All right. So next Tuesday, how much do you think you can pay?
I'm planning on 1,000.
About 1,000? Okay.
Yeah.
I'll put that in the file.
Okay.
And that's going to be on the 11th, but I'll put the 12th.
Okay.
I will adjourn this matter out to November 14th, 2025 at 3 p.m.
3
Ma'am,
p.m.
that is an in-person hearing, so you'll have to appear at the courthouse for that hearing if it's not all paid.
Okay.
All right. Thank you.
Thank you.
Lakestone Apartments versus Shortavia. Is it Muscat? Was that it for Mr. Freeman? It was.
May it please the Honorable Court, Steve Gann, P 78219 for the plaintiff.
Not checked in.
Muscat? And I do not see him. My staff has told me they have not checked in. If you'd like to take a default, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. At this time,
Go ahead.
there is currently owing $13,343.60 in rent. There is $337 in court fees for a total of $13,680.60. And we prayed for a money judgment on this, so I'd asked for a money judgment on this matter. I got an email from my client a few minutes ago that they turned in the keys, so this is down to a money judgment at this point.
All right. And that amount, I'm sorry, counsel, was $13,000.
The total amount with court fees, $13,680.60.
Got it.
Thank you.
All right. Judgment
To
to
the
the
best of my
plaintiff. That
knowledge,
is
go
ahead, sir.
I just complete the record for you, Your Honor. To the best of my knowledge, the defendant is not in the military, not incompetent, is over the age of 18, and otherwise able to attend the hearing today, and the property is kept fit for its intended use.
Judgment to the plaintiff, that is by default for possession and money. Redemption amount is in the amount requested, as well as money judgment.
I'm sorry, Your Honor. I'm sorry. My network is out. I am here.
What is your name?
Shartavia Mushat.
Accurately stated.
Yes, Judge.
Ms. Doty, how old are you?
24 years old.
How far did you go in school?
10th grade, but I'm currently a student in Smart Schools High School in Arizona.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
Yes.
What are you taking?
Acyclovir, 400 milligrams twice a day.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today because I don't know enough about you and I don't know enough about this case yet. What we're going to do is set this for sentencing. That's going to take place in about 6 to 8 weeks. I'm going to receive a pre-sentence investigation, and my plan is to put you on probation. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Mr. Guyman before you signed it?
Yes.
Are you satisfied with the representation that you've received in the case?
Absolutely.
You're going to enter a plea of guilty to 1 count of illegal conveyance of drugs of abuse onto the grounds of a specified detention facility. That's a third-degree felony punishable by up to 36 months in prison and a $10,000 fine. There is no mandatory prison, but if you violate the terms of your supervision and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, to compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on January the 17th of 2025 at Lebanon Correctional Institution, a state detention facility located in Warren County, state of Ohio, that Ms. Doty was visiting co-defendant inmate Malik Shaw, and during that visit, corrections officers noted a strong odor of marijuana. When she was questioned, the defendant admitted that she had items on her person, that being 3 red balloons containing what was later tested to be 11.5 grams of marijuana, a controlled substance.
Anything on those facts, Mr. Garman?
No, Your Honor.
Ms. Doty, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes.
Do you understand the rights you're giving up by entering a plea?
Absolutely.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. I'm going to do a level 2 pre-sentence investigation. We're going to come back here in about 6 to 8 weeks for sentencing. Make sure that you go back down to pretrial services, fill out the paperwork for the PSI.
Yes, sir.
Anything else?
No.
All right, that's all.
Thank you.
It blinked
Okay.
out as soon as you called it. I apologize.
Okay. My understanding, at least, what I've been informed is you turned in the keys.
Yes, sir.
All right. So you're surrendering possession of the premises?
Yes, sir.
All right. Very good. And there is also a money judgment that the plaintiff's requesting for, I'm assuming, rent owed in the amount of about $13,680, $80.60. What do you have to say about that, ma'am?
So I actually, back in October of 2024, I went to the office to pay my rent, and I had legal advice coming from legal aid that Mr. Gann was privy to. I had a neighbor who I had a PPO against. She had a lot of different violent acts that she had committed against my family and myself. And the office in turn tried to evict me in the situation. And when legal aid, the attorneys from legal aid reached out to Mr. Gann, there was no answer. But I was told when I went to pay my rent in October 2024 not to do so. And I do have a video of the leasing manager, I went to drop my money order in the box and she stated, "We are not accepting your rent." And so there was no
Well, that's
correspondence
because there was a
between-
that's because they were going to try to terminate your tenancy if they were coming after you.
But then there was no correspondence after that at all. That was the last thing I was told.
So ma'am, are you claiming that you don't owe this money?
Yes, sir.
All right, then what I'm going to do is I'm going to set this matter. Give me a Tuesday,
The 18th.
the 18th.
Yes.
I'm going to set this matter for final settlement conference. Likely we will be, if we can't resolve it at that point, then I'll be setting a trial date. I'll set a final settlement conference for November 18th, 2025, 9 a.m. That is an in-person hearing, so you must appear at the courthouse.
Thank you, Your Honor.
November 18th at 9 a.m.
Yes, ma'am.
Okay, and I did want to also state that, again, that Mr. Gam was reached out to. My attorney at that time, he said he did not receive any correspondence back. He wasn't really sure what to do at that point. We tried to meet with the office and do all kinds of different things. That unit that I was
Ma'am,
living
I'll
in-
hear
I'm
all
sorry.
of this on the 18th.
Okay, thank you.
Thank you.
Thank
Have a
you, Your
good one.
Honor.
Thank you, sir. Ledgestone Apartments versus Lafita Thompson.
May it please the Honorable Court, Steve Gann, P 78209, appearing for the plaintiff on this matter.
She's here.
Ms. Thompson, she's
Yes.
here. Where's-
Yes, I'm here.
Oh, there you are. Okay, I'll need a camera, ma'am. What? Mr. Gann?
At this time, Your Honor, there's currently owing $776.59, $776.59, $212 in court fees for a total of $989.59, and majority of this is made up of utility bills.
Got it. All right, Ms. Thompson, what do you have to say about this?
I don't believe I owe all this money because I just came to court paying all this stuff August the 1st. So I'm going to go back to my legal aid attorney and have him to look over all my stuff. And my papers say that they are only asking on my court papers is $309.70, and I don't understand where all the rest of it come from. So.
All right, if you're going to seek the advice of counsel, I'm going to adjourn this out to next week. I will adjourn it to November 14th, 2025, 2 p.m. That is an in-person hearing, ma'am. Should talk with your counsel, and you do have to appear at the courthouse.
Okay.
Thank you.
Thank
Your
you.
Honor, Your Honor, would it be possible to make it at the same time as the other case on November 18th?
No, only because I set that for a final settlement conference, so it's
Sure.
advanced.
Okay,
All right.
so it's the 14th at 2 p.m.
Yes, yes, sir.
I believe
right.
that concludes my morning
Thank
call.
you.
I'll be back this afternoon.
Yes,
Thank
sir.
you.
Thank you.
Thank you. Hamptons of Clover Lane versus Stephen Shelton.
Good morning, Your Honor. Sumchit Hart, P69542 on behalf of Hamptons of Clover Lane.
This is like a bad penny that shows up and it's now coming back again. So, I mean,
Like a
well, okay.
Oh,
Okay,
like-
bad penny. Bad penny was a bad thing. I didn't mean to put it that way. Anyway, good morning, Ms. Hart.
Good morning, Your Honor. Plaintiff moves to dismiss Mr. Shelton's case. A dismissal.
All right. That case is dismissed. He is Mr. Hart. Shelton, I'm sorry.
Yes.
He signed off. Okay. So he probably heard it was dismissed and got out. Hamptons of Clover Lane versus Troy Williams.
Sumchit Hart on behalf of Hamptons of Clover Lane. Likewise with Mr. Williams, we're dismissing his case as well.
You broke up there, Ms. Hart. You're breaking up.
Oh, I apologize, Judge. We're dismissing Mr. Williams' case as well.
All right, Mr. Williams, you have any objection to that?
The only concern I have is that the case was filed after I paid, so I'm thinking that a refund of court costs might be in order. The case, according to the
When
stamp,
did
was
you pay?
I paid on the 16th of October, and the case
And
was
it was
filed.
signed off on, I understand that, but it was signed off by the attorney on the 14th.
Okay, no objection, Your Honor.
All right, thank you. Court calls the case of Hamptons of Clover Lane versus Claire Updike.
Some hard on behalf of.
Miss Updike, there you are.
Yeah.
All right. What is plaintiff's claim in this case, including court costs?
Including court costs, Your Honor, $3,511.37.
Ms. Updike, how are you intending on getting this paid?
I've requested a hardship withdrawal from my 401k. It's going to take a few days to process, but I also get paid on the 15th of November. So I should be able to pay in full with late fees and court costs on the 17th of November.
Okay, you think you can pay everything by the 17th?
Yes, sir.
All right. Ms. Hart, I would adjourn this to the 14th, or given what she said, do you want me to try to put it out to the 21st? Whatever your pleasure.
Judge, I'd respectfully request the 17th or the 14th.
The 14th? Okay. Okay, ma'am, if you get your hardship withdrawal from your 401k, I marked a file that that's what's happening here. If you get that paid over to the landlord, whatever portion of that you have, okay?
Yes, sir.
And then what I will do is I'll set this for an in-person hearing for November 14th, 2025 at 1 p.m. That is an in-person hearing, so you'll need to come down to the courthouse, okay, ma'am?
Will do. Thank you, Your Honor.
Thank you. That it for you, Ms. Hart?
I believe so, Judge. We've submitted some additional dismissals.
Okay, they probably took them off then. Or they're probably at the end, so we're good.
Okay,
Alrighty.
Your Honor, have a great
Thank
week.
you.
Good to see you.
All right, good seeing you also. Is there more?
Yeah. She's got the one in your
Oh.
hand plus these.
You, Miss, where is she? So she does have.
She has 4 more cases, the one in your hand plus these 3.
All right, send her an email. Court does call the case of Arbor House versus Trayvon Modoc.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Modoc, they're not here. If you'd like to take a default, raise your right hand, sir. Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do, Your Honor.
Go ahead.
Your Honor, this is a non-payment rent possession case. There's second mailing by the court. At this time, requesting default judgment. To the best of my knowledge, the defendant is not in the military, a minor, or unable to stand trial. To the best of my knowledge, the property is being kept habitably. Currently, there's a balance due, including court costs totaling $1,860, requesting a default judgment in that amount with writ to be issued after November 17th.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ to issue 10 days.
Thank you, Your Honor.
Sir.
And
Thank
I think
you.
the rest of mine today were dismissed. I think I have 3 dismissals.
Yeah, so let me call those real quick. Arbor Club versus Kimberly Jones, Arbor House versus Levy Anderson, Arbor House versus Antonia Robles. All of those matters are dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a good weekend.
You do the same, sir. Court does call the case of Arbor Manor versus Jamaica Jones.
Good morning, Your Honor. Parissa Gazari appearing for plaintiff.
I'm here.
Hello, Ms. Jones. All right.
Hi.
All right. What is plaintiff's claim?
Your Honor, the outstanding balance is $2,841, which includes court costs.
Righty. And Ms. Jones, how were you intending on getting that paid?
Your Honor, I stated that it was $119.71.
119.
So it was $1,971.
All right. So you're about 1,000 off, but what's your monthly rent?
The monthly rent is $657.
Okay, so let me ask you this. If I take that amount, I'm just approximating numbers, plus your court costs, I'm going to get up to around the figure that plaintiff's claiming. Are you looking at your total at the end of October, not including your November?
Yes.
Okay, so the number that plaintiff is giving me, because we're in November, is what you owe through November.
Okay.
Okay, so in any event, how are you intending on trying to get this paid?
I applied for the emergency thing through DHS. I also
Okay.
have $1,100 in money order. The reason why I haven't paid for it was because they have not fixed anything in my house that I put in order for.
All right, so you have repair issues?
Yes.
So what I'm gonna do is I'm gonna require that you file a written answer with the court. You need to file that written answer by November 13th. You need to provide a copy to plaintiff's counsel of that written answer listing out your reasons for why you haven't paid the rent. I will adjourn this matter out to November 14th, 2025 at what?
12 noon.
At noon. That is an in-person hearing. You must appear at the courthouse. There is also a form in the packet that you received called a rental assistance form. If you've applied for SER, you need to fill that form out, submit it to the court. That form needs to be in the court by next Wednesday.
Yes, sir. Yes, sir.
All right. Okay, thank you. We'll see you next week.
Thank you.
Cherry Hill Administration versus Dion Ragland.
Marissa Gazari for plaintiff.
They're trying to unmute. She's staring at that screen, willing to unmute. All right. Good morning, Mr. Ragland.
Good morning.
All right. What is plaintiff's claim in this case?
Your Honor, the outstanding balance is $9,749, which includes $175 in court costs.
All right. Okay, Mr. Ragland?
Yes,
All right. How are you intending on getting that paid?
I have money orders stating that I have paid up, and I have documents to send to the court to show that I have paid rent.
Okay, so
I have paid $8,280 of money orders that I have, plus my security deposit and a cleaning fee that they charged me for.
okay, I just want to make sure I'm following you. You say that's the total amount you paid since you moved in?
Yes, what they
Okay.
say that I owe.
I'm sorry. What'd you say?
The total amount says 1224.
I have a money order from 12/04/24 stating of when the last time I paid rent up until now. I have money orders to show that I have paid.
Okay, so just so that I'm clear, you, based upon what you're telling me,
Yeah.
you're saying you paid everything except about $1,500 of this.
Yeah, so whatever,
Right.
whatever, they just, yes.
Okay, all
I
right.
can send the email over to you guys today to show the courts.
Well, I don't know that we're gonna be able to resolve it
Okay.
today.
Okay.
Okay, if you've got all of those money orders, what I'm gonna need is for you can send a copy to the court. I'm still gonna adjourn the case out, okay?
Okay, that's fine.
So if you want to send a copy to the court, you can, and I'd suggest that you do, and also send a copy to the attorney's office for the plaintiff, for your landlord,
Okay,
okay?
yeah,
So that everybody can begin to compare numbers. I will adjourn this out to November 14th, 2025 at noon,
Yes.
at 12 noon. That's an in-person hearing, so I'll need you to come down to the courthouse. And I think I'm pretty good at math, so I can look at it and try to figure out where we are. All right?
all right. There you go, yeah.
Okay,
For the email.
okay.
Can I have
We'll see you
the
then.
email? Can I have the email?
I'm
sent
sorry?
to the court? Can I have the email?
Yes, can you put that in the chat for them? We'll put it in the chat for your worker that's there,
Yes,
Ms. Horton.
Yes, good
We'll
morning.
send that. Good morning. So we'll put it in the chat for the email for him to get the documents to us.
Okay, thank you.
All right, thank you guys. You guys have a great weekend.
all right, you too. Thank you very much.
Thank you. Forrest Knoll versus Samaya Charles.
Marissa Gazari for plaintiff.
This is Shemaya Charles.
Okay, hello, Miss Charles.
Hello.
All right. Good morning. What is plaintiff's claim?
Your Honor, the outstanding balance is $816, which includes court costs.
816?
Yes.
All right, Miss Charles, how are you intending on getting that paid?
Well, they got 622 on October 13th. I had the receipt right here, and I only owe them 344 for October, and I have the money order right here that I can drop off to the
I got you.
office. Yep. So I don't owe anything except for November's month. So once I give them this other money order.
Hold on, Miss Charles. You were moving fast there.
I'm sorry.
No, it's okay. What's your monthly rent?
My monthly rent is $297.
$297. Okay.
Yes.
And then so you got about 300 of monthly rent. You're going to have court cost in this because November's not paid, and so you're saying their number is off.
Yes.
Well, you have a balance though from November or from October that you haven't paid, right?
I have from September and October that I have not paid. I was 2 months.
Okay.
behind. Yeah. No, I take that back. It was August, September, and then I had owed October when I got this notification. So I technically owed them 3, and that came out to be $966 from the paper that's right here.
That you owe.
Yes, that I did. Oh, yep. And I gave them 622 on October 13th.
Okay.
And then I just got this printed
you're going to be about 300 short.
I got the 300 right here for October, and I know I still owe for November.
Okay. Hang on. I'm just looking at the numbers that the plaintiff has. So you got about 300 that you owe them, but you got the money for that. And then you're going to have about another 300 for November.
Yes, sir.
And then you got court costs on top of that. So it looks like just ballparking this number, it looks like it's about right, or it is right.
That I still owe 800?
Yes. So once you pay, just listen, once you pay the 300 that you got in your hand.
Okay. Well, I'm not even talking about
number,
that.
Hang on. That number is going to go down to about 500. If you pay your November rent, that number is going to go into the 200 range or whatever the costs are, and that's what you're going to owe.
Well, how much is court fees?
Okay, well, 175. 175.
And I have to pay the court fee?
Yes, ma'am.
Oh, that's different. Okay.
Okay. So you see where the number's coming from?
I mean, I guess so. I don't see why I have to pay a court fee and they want me to come to court, but I guess I'll do what I got to do.
Well, that's because you didn't pay. That's because you didn't pay your rent, but you got to pay it.
I mean, I'm going to pay my rent. Regardless, I'm going to pay the rent. That's fine with me.
Okay, you're going to have to pay the court costs. If you want me to order it, I'll order it. But listen.
I understand, Your Honor. I understand.
Okay, so here's what I'm going to do.
Okay.
How much you're going to get the 300 or whatever you got in the money order over to them?
Yes, the 344. Yes, for October.
Okay. So when is the next time you can make a payment after you get that over?
I won't have no money until next week for November month.
Okay. So what day next week you think?
I want to say next week, either Thursday or Friday. I'm not entirely sure, but the latest is Friday.
All right. So what I'm going to put in the file is you're going to pay the 300 to them. Mm-hmm. I'm going to adjourn this out to November 14th. That's next Friday.
Okay.
2025 at noon.
Okay.
Okay. That's an in-person hearing. So you'll need to come down to the courthouse.
Okay.
Okay. All right. And we'll see you then so you can argue with me in person.
All righty. That sounds good to me, Judge.
Wow. She just said, okay, I'm coming to argue. Okay.
I'll make sure I'll be there at noon on the dot.
Yeah. All right. Yes, ma'am. Have a good weekend.
You as well. Thank you, Your Honor.
Thank you. Forrest Knoll versus Nicole Kuhn.
Marissa Gazari for plaintiff.
Nicole Kuhn, they are not checked in. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
Your Honor, the rent to retain possession is $1,331, court costs of $175 for a total redemption of $1,506. Plaintiff is requesting entry of a default judgment for possession with a writ to issue after 10 days if the total amount remains unpaid.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested. Writ to issue 10 days. Horace Knoll versus Rosalind Lett.
Carissa Gazari for plaintiff.
Oh, she's here. Okay. Hello, Miss Lett.
Morning.
And what is plaintiff's claim?
Your Honor, the outstanding balance is $1,253, which includes court costs.
Okay. Miss Lett, how are you intending on getting that paid?
I have a check coming next Wednesday. Should be about 500. And then the rest, I will DoorDash. I'm just asking for 10 days. I was completely irresponsible. It's my fault.
Wow. I don't usually get that. Okay.
Yeah, I went negative on my cards. And then so it was taking my checks. And so I was just getting pushed back.
Okay.
But it's my fault. It was my fault.
Okay, let's work it out. You're gonna have 500 next Wednesday, the 12th. Okay. And then you're gonna need additional time to pay that other amount?
And I will DoorDash the rest. Yeah, I'm just asking for 10 days. Yeah.
All right, well, here's what I'm gonna do. I'm gonna adjourn it out 1 week. Let's get the 500 in.
Okay.
And then we'll see where we go from there, okay?
Okay.
So I'll adjourn it out to November 14th, 2025 at 12 noon. Okay?
Okay.
That's an in-person hearing, so you'll have to come down to the courthouse to appear, and then we'll see where we go with the rest of your case. Miss Irresponsible. All right?
Thank you.
No, let me quit. All right, you take care. We'll see you then. River Drive Apartments versus Ann Marquette.
Carissa Gazari for plaintiff.
And I think Miss Marquette is here. And Miss Marquette, I cannot hear you because you're muted.
There we go. Can you hear me now?
I can. And
Good morning. How are you?
I'm wonderful. Thank you for asking. I hope you're doing well.
I'm doing
All right.
well.
All right. What is plaintiff's claim in this case?
Your Honor, the outstanding balance is $3,912.46, which includes court costs.
All right. Ms. Marquette, how are you intending on getting this paid?
All right, Your Honor, I have a hardship with Fidelity, and they told me it's coming in on the 15th. I get paid on the 13th, and I can give them around $700 then. The Fidelity check should be around $2,000, and then 2 weeks after that, I get another check that should make that caught up. And I've also applied for assistance.
Okay, so you applied for what, the state assistance?
I applied for state assistance. I applied for St. Vincent de Paul. I applied for Red Cross, and I applied for Hawk.
Okay, so let me just get this right. You'll have 700 on next Wednesday, you think, right?
Wednesday or Thursday. Yes, sir.
Okay, so I'll just put the 12.
Okay.
You'll have the 700. You've got another check you think coming in when?
On the 15th, I'm drawing a
Okay.
hardship off my 401k.
Gotcha. So you got the 401k.
Yeah.
All right. So what I'll do is I'll adjourn this out to November 14th, 2025 at 12 noon. Okay, that's an in-person hearing, so you'll need to be down at the courthouse.
Yes, sir.
What you're also going to need to do is in your packet, there's a rental assistance form.
Yes, sir.
Okay, fill that rental assistance form out with the information, particularly regarding the SER.
Yes.
And it needs to be filed with the court by next Wednesday.
No problem. I will drop that off later this afternoon, Your Honor. Thank you so much. Thank you, Attorney.
All right, thank you. Have a good weekend. Thank you.
Bye-bye now.
Bye-bye. River Drive versus Jalen Grant. That matter's dismissed on plaintiff's motion without prejudice.
Thank you, Your Honor. Have a wonderful day.
You do the same. And Ms. Hart is back. Onyx Real Estate Solutions versus Jennifer Smith.
Good morning, Your Honor. Assumption Hart on behalf of plaintiff. Plaintiff moves to dismiss this matter.
Okay, that's probably why. Miss Smith, you're here? Oh boy, she got a big smile. Miss Smith, Miss Smith, you have any objection to that? No, she's not even gonna unmute. She's just smiling and she's saying no. All right, case is dismissed. You have a great weekend, Miss Smith. Orchard Grove versus Robert Holliday.
Sumption Hart on behalf of plaintiff.
He is not checked in. Did you wish to proceed on that?
Judge, we actually, plaintiff is moving to dismiss this case as well.
All right, that case is dismissed. That may be why you laughed, because all of these, are the rest of yours dismissals?
Yes, Judge. I'm sorry. I misunderstood. I thought you said that I was excused.
No, that may have been my fault, but Orchard Grove versus Elizabeth Johnson.
Sumption Hart. I'm sorry.
And Marcus Johnson.
Thank you, Judge. Plaintiff moves to dismiss this case as to both defendants.
All right, that case is dismissed. And Orchard Grove versus Christine Holmes and Larry Holmes.
Sumption Hart on behalf of plaintiff, likewise with these two defendants, Your Honor, we are moving to dismiss this matter.
All right, that is dismissed. Okay, you probably don't remember because you haven't been before us in a while and it's a little bit changed. If we don't get the dismissal, it stays on our docket. That's why.
Absolutely.
So we didn't have it in there. So we're good.
Completely understand. Thank you so much. Have a great weekend.
All right, you too. Take care.
Judge, you'll be seeing a lot more of me. I think that 14A's, I think my assignment from now on. So.
Oh boy. Look at that was an expression of happiness. I know. Actually, I look forward to it. Miss
Have
Hart.
a good day.
We missed you. You do the same. Take care. All right, court stands in recess.
All right, you got your ticket on.
Hacer carreras conlleva 6.
All right.
Thank you, Your Honor.
Thank you. Mr. Bush, let's take Miss Richmond. Miss Harden, I'm not going to make you sit here all morning. We'll wait a little bit. Paul?
I'm having a hard time getting, is she?
She's
do I have
here.
to log in?
Yeah, well, just get in the Zoom room. I've got it open.
It seems like there's no room, like it wants me to sign in to Zoom.
No, I'll bring it in.
Okay.
Do you want me to see if I can help him?
No, I had it in the waiting room.
Right, but you have to, if it's not been booted up, you have to actually join your meeting.
Yes, if you could, thank you.
Yeah.
No, he's got it.
Okay, perfect.
Yes. Yeah.
Good morning.
Good morning.
Adam Fights and Rights, can I approach you?
Sure, thank you. Vivian, Mr. Gibson is located as.
Yes, sir, Your Honor. I just got a rehab, so I'm just getting going. I have an interview at Lowe's Tuesday morning.
All right, that sounds good. Like you're making progress. Glad that you were able to do rehab successfully and that things are looking up for you.
Well, thanks to you, Your Honor. I have my certificate right here for 6 months of life challenges.
That's awesome.
Yep. I want to thank you. I put God in my life, and
it was the right fit for me. I'm just blessed today. And that's because of your order. I just want you to know that.
Thank you very much. I appreciate the kind words. The biggest thing that you can do to thank me is continue to stay on the straight path, right?
I am, Your Honor. Yes, I will.
Sounds like you're in a good place today, and I'm really pleased to hear that. So we will put you on an extension of your probation for 12 months. We won't charge you any additional fee for that. And as long as you make your payments, we should be good. You're going to need to contact the probation department. Do you have the number for that?
Yes, I probably will be in there today to make a payment, if that's okay.
Right. That sounds good. So Ms. Hill will look for you.
Okay.
And hopefully things continue to go well for you, sir. All right. Thank you. That's all for today then.
Thank you. Have a good day.
You too. Next case is the state of Michigan versus Nelson Nicola. That's file 25-43662-FY, set for probation violation. We have Nelson with us. I do not see him. All right. Nelson has not appeared to call the court, does not appear to be in the waiting room. Ms. Hill, your recommendation?
I would do an order to show cause, please.
All right. For the failure to appear, we will do an order to show cause. State of Michigan versus Jesse Ginther, file 23-42452-SD. I do see Mr. Ginther is with us. Mr. Ginther, the probation violation allegation is that you failed to call the testing line or test as required, and you stopped calling on May 6th of 25. There's a second non-technical violation alleged as well, in that you absconded from probation, and absconded means that you were gone for a continuous period of not less than 60 days. There are multiple prior probation violations, including 3 technical violations. So the recommendation is that you serve 93 days in jail, you be given credit for any time served, and that you be discharged from probation unsuccessfully. Do you understand the nature of the allegations made against you?
Yes, I understand.
Do you understand the recommendation made as well?
Yes, sir.
You have the right to have a hearing in front of me. You do not have the right to have a jury trial. At that hearing, you'd have the right to see, hear, and question the witnesses against you. You'd have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You could testify, or you could choose to remain silent, and that silence could not be used against you. You'd have the right to be presumed innocent until proven guilty by a preponderance of the evidence. There's a lesser burden of proof in a probation violation hearing, and that burden of proof would remain with the probation department at all times. Finally, you'd have the right to have an attorney, and you'd have the right to appeal. Do you understand all of those rights?
Yes, sir.
Do you have any questions about any of those rights?
No, not about the rights, sir.
All right. What would you like to do today?
I'd like to get an attorney. I thought it was off probation. That's why that was the mislapse of it and stuff. So I wasn't, this is all new to me, what was going on with this.
Well, you've struggled with complying with your probation all along. You had a technical violation. You absconded in June of 24, came back in a technical violation in January of 25, another technical violation in March of 25, and another technical violation in May of 25. I don't know why you think that you were off probation with all that problem.
The first skip of the probation was just miscommunication between me and Miss Hill. Um, I did all that with the last judge, explain all that stuff. But this last one, why I didn't call Miss Hill or none of that, I thought the last time we spoke was a sentencing of 5 work days to be completed and paid, and then I was, from my understanding, I was supposed to be off probation once all that stuff was done. Obviously, I was wrong. I did not know that. There must have been other steps I needed to do. I was unaware, and I'm sorry for that and would like to figure this all out. So,
all right. I'm going to have you contact the court-appointed counsel administrator. His name is Gary Gilo. He'll determine whether or not you qualify for court-appointed attorney. If he does, he'll appoint an attorney to represent you, and then that attorney can file an appearance and contact Ms. Hill and begin try to resolve the matter. We'll set another hearing date in about 2 weeks to see where we're at with that. So do you have a number? Do you have a pen or paper that you can write down a number with?
Yes, I do.
989-732-8030 is the number for Gary Gilo's office. You can tell him what your name, tell his secretary what your name is, and that you have a probation violation in which the judge sent you to them to determine whether or not you could get a court-appointed attorney.
Okay.
Any questions that you have?
Not at this time.
All right. The number that we have, or the place that we have for you to send notice, is on Park Drive in Grayling. Is that accurate?
North Park.
North Park Drive in Grayling, right? So we'll send the notice. We'll send the notice of the next hearing there. Ms. Hill, is there anything else that you want him to do in the meantime?
If he could contact me, we can get him set back up on the testing.
All right. So if you, Mr. Ginther, if you'd call today, or you want that today, or you want that on Monday, Ms. Hill?
Monday, please.
All right. Let's do it on Monday because she'll be in court with me most of today. So Mr. Ginther, call probation department and then call Mr. Gilo, starting with today with Mr. Gilo. Any other questions you have, Mr. Ginther?
I don't think so.
All right. That's all for today. Then I'll see you in a couple weeks.
All right. Sounds good. Thank you.
.435. Ms. Roberts, it looks like there is a allegation of a probation violation that says that you tested positive for alcohol on September 24th and October the 2nd of 2025. The recommendation is that you complete 2 work camp days in lieu of jail to be done within 30 days. Do you understand the nature of the allegation made against you?
Yes.
Do you understand the recommendation that's been made?
Good morning. Oh, can you hear me?
Yes, I can hear you.
Okay. All right. Yeah, this is. Are you the judge?
No.
Oh, I don't know who I'm meeting.
Oh yeah, I'm supposed to be meeting the judge too. I think they just told me mine was dismissed, so I'm okay.
Oh, okay. Yeah, I don't know.
All right.
I ended up in the same Zoom.
Yeah, I see. All right, sir. You have a nice day.
All right, you too, buddy.
Yes, I do.
All right. As to those allegations, you have the right to have a hearing in front of me as the judge. You do not have the right to have a jury trial. At that hearing, you'd have the right to see, hear, and question the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. You could testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You'd have the right to have to be presumed innocent until proven guilty by a preponderance of the evidence, that is 51% of the evidence, and that burden of proof would remain with the probation department. You'd have the right to an attorney, and you'd have the right to appeal. Do you understand those rights?
Yes, I do.
Do you have any questions about those rights?
No.
What do you want to do today? Do you want to admit those allegations? Do you want to deny them? Would you like to have an attorney?
Yeah. Oh, I did it. I slipped up a couple times, but it's taught me a valuable lesson, and I'm working really hard in counseling and group and AA and with my sponsor, and came up with my counselor gave me a list of 50 coping mechanisms.
Oh, good.
When that happens, and
sounds like you're back on the right track. All right.
Yeah.
If you want to admit to that, you'd be giving up your hearing rights. Do you understand that?
Yes, I do.
All right. Is that still what you want to do?
Yes.
All right. If you raise your right hand so I can swear you in.
Okay.
You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Go ahead and put your hand down. Has anybody promised you anything to get you to do this today?
No.
Has anybody threatened you in any way to get you to do this today?
No.
Are you doing this of your own free choice and free will?
Yes.
All right. The probation violation allegation is that you tested positive for alcohol on September the 24th. Why did you test positive on September the 24th?
I had just found out that my dad was in the hospital and he had pneumonia. He's 89, and they didn't think he was going to make it, and he's not here. He's in Texas. So that was freaking me out, and I stressed out really bad about it. And what I ended up doing was going to the store and getting those little tiny airplane bottles. And I drank two of those. I thought, well, it's just take the edge off, you know? So, I mean, I didn't, even though it doesn't make it any better, I didn't go crazy and, do a binge or something.
But you knew you weren't supposed to be drinking at all, right?
Oh, yeah, I knew that.
All right. Then what happened on October the 2nd?
That's when I got diagnosed with myself with, I have lung issues, and it was like your lungs are equivalent to a 111-year-old person, which, yeah.
So what did you do in response to that?
Well, I'm working with some people to try to quit smoking. That's, that's the big issue. It's not an easy thing to do.
Did you use alcohol on October the 2nd?
Yes.
What did you drink?
And it was the same thing, the little bottle. It was vodka, just the little.
Okay. So what did you learn from these two episodes?
That I probably have a problem, and I need to investigate it, and I need to, just work harder.
Okay. And did, in either of these cases, did drinking that little amount of alcohol really change anything?
No, it just for the time being, it made me feel a little bit better I don't know.
Okay. But here's what happened. It's now making you feel a whole lot worse, right?
Yes, sir.
Okay. Do you believe that you're strong enough to do this without alcohol?
Yes.
Okay. That's a progress, right? Because in the past you've not believed that. See, what you're feeling is totally normal. Something bad happens and we feel bad, and we want to make that bad feeling go away. alcohol promises, it makes you think that that bad feeling is going to go away. And it might for a minute or two, but it comes back worse, just like you're experiencing today, right? So alcohol is just a lie. It lies to you. It tells you it's going to make you feel better, and it really doesn't. It makes you feel worse. It depresses you even more. Okay? So keep doing what you're doing with your treatment. Keep doing what you're doing with your counseling. We're going to have you contact the probation department in a few days, Monday or Tuesday, and set up this work camp in lieu of going to jail. And you must do that within the next 30 days. Do you understand all of that?
Yes, sir.
You have any questions about any of that?
No.
You know how to contact Ms. Hill, right?
Yes, I do.
Okay. As long as you keep doing the positive things like you are, I think you're going to be fine. We all have difficult news that comes to us, whether it's about our dad or whether it's about our own personal health. All of that happens to everybody. You just got to keep being strong. And if you feel like something's coming on where you think alcohol needs to be used, that's what those 50 things that your counselor gave you is for, right?
Right.
Okay. All right. That's all for today then. Thank you, ma'am. I appreciate your time.
All right. Thank you.
State of Michigan versus Gavin Van Lushing, file 24-43158-SD. I do see Mr. Van Lushing is with us. All right, Mr. Van Lushing, the allegation against you is that you tested positive for alcohol on September the 19th of 2025. The recommendation is that you serve 5 days jail, released to work camp to complete 3 sanctioned days from your last violation. Do you understand the nature of the allegation made against you?
Yes, Your Honor.
You understand the recommendation made?
Yes, Your Honor.
As to that recommendation, you have the right to have a hearing. At that hearing, you have the right to be represented by an attorney. You have the right to see, hear, and question the witnesses against you. You have the right to present your own witnesses and evidence and get a subpoena from the court to make those witnesses appear and testify. You can testify or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You have the right to be presumed innocent until proven guilty by a preponderance of the evidence. That's a lower standard than in a criminal case. And that burden of proof would remain with the probation department. Finally, you have the right to appeal. You understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
I would like to seek legal counsel.
So you want an attorney? Are you working right now?
Yes, sir.
Where are you working and how much are you making?
I work for my father's company.
How much are you making?
I make $3,100 a month. Get paid by the month.
Okay, so about $36,000 or so, $37,000 a year.
Yes, Your Honor.
All right, I'm going to have you contact Mr. Gilo's office. He's the administrator of the court-appointed attorneys. Do you have a pen and paper you can write down his number?
Yes, Your Honor.
989-732-8030.
Okay.
We're going to reset today's hearing in about 2 weeks to find out where we go from here. So you need to contact Mr. Gilo immediately. If you do not qualify for a court-appointed attorney and you want an attorney, you need to get on stick and get yourself an attorney.
Yep, and I had one. I have one. He was out of the office for 10 days, so I'm waiting to get back with him. He's got health issues.
Okay. So we'll see you in approximately 2 weeks or so, either with a court-appointed attorney or with your own attorney, and then we'll decide where we go from here on this probation violation. Do you have any questions for me?
No, sir.
Ms. Hill, is there anything that Mr. Van Lucien needs to do right now for you?
No, Your Honor, he's in contact with me.
All right, that's all for today then, Mr. Van Lucien. Thank you.
Thank you.
Three 615-43690-FY. I do see Mr. Hooker is present with us. All right, Mr. Hooker, in the 43690 file, there is a probation violation allegation that you were unsuccessfully discharged from the batterers program and men's group, and that you failed to provide proof of counseling. There's a note that says that the men's group will allow you to start over if ordered to re-enroll. The recommendation in this file is that you complete 2 days of work camp in lieu of jail within 30 days, and that you re-enroll in the men's group and complete it successfully and hold 5 days of jail in abeyance pending your successful completion, and to be used if you don't successfully complete it. The other file is 43616, and it has the exact same allegation and recommendation in it. Do you understand the nature of the allegations made against you?
Yes, Your Honor.
You understand what the recommendation is in each file?
Yes, Your Honor.
As to each of these files, you have the right to have a contested hearing in front of me. That would be in front of a judge, not in front of a jury. At that hearing, you'd have the right to have an attorney present. You'd have the right to see, hear, and question the witnesses against you. You'd have the right to present your own witnesses and evidence and get a subpoena from the court to require those witnesses to appear and testify. You could testify or you could remain silent, and that silence could not be used against you. You'd have the right to be presumed innocent until proven guilty by a preponderance of the evidence, and it's not the higher standard for a criminal trial beyond a reasonable doubt. And you'd have the right to appeal. Do you understand all of those rights?
Your Honor.
Do you have any question about any of those rights?
No, Your Honor.
Do you wish to have an attorney?
No, Your Honor.
How do you wish to proceed today then?
I'd like to re-enroll into the men's program and see about if I can complete the 2 days of work camp.
All right. Would you raise your right hand so I can take some testimony from you? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, go ahead and put your hand down, sir. Has anybody promised you anything or threatened you in any way to get you to enter this plea today?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
The allegation against you is that you were unsuccessfully discharged from the men's group and the batterers program. Is that true?
Yes, Your Honor.
Do you know why that happened?
They didn't tell me specifically, but it was because of I think I fell asleep during one of the sessions.
You really think they kicked you out because you fell asleep once?
I'm not sure they didn't tell me.
Well, here's what the note that I've received is, this is October 16th of 2025, said he had to, this is the clinical therapist. He had to remove you from group this morning due to you sleeping. There's the once. Says, I gave him an opportunity to wake up, but he did not. His level of participation has been abysmal at this point. Between his no-show several weeks ago and this, I am unsuccessfully discharging him for being non-compliant.
I don't know. Well, I work nights 4:30 to 1 a.m. and then that is early in the morning along with the drug testing. So I stay up till 3:30, 4 in the morning to do the drug testing call. So I don't got to wake up at 8:30 in the morning or 8 in the morning because it ends at 9. So it's just a lot of scheduling issues because I work 4:30 to 1 in the morning. I don't go to bed till 4 a.m. because I have to do the drug call testing. And then so I wake up to do that. And at the time I had no heat or power. So my heater had ran out of fuel that morning. So there was no way for me to get warmth besides under a blanket.
Mr. Hooker, life is hard for lots of different people. And I get what you're telling me. It's a challenge. I'm not minimizing your challenges, but if you're going to counseling and you are sleeping through it, what good is the counseling doing you?
In all honesty, I haven't really been getting a lot from this counseling.
Because you're not prepared to go to it.
Well, I am prepared to go through it. They've all just been doing it, saying that women just don't, they're weak. You can't talk to them. You can't defend yourself. Because if you defend yourself, that's aggressive behavior.
Okay, Mr. Hooker, if you were doing the same behavior at work, what would happen to you?
I'd be fired, but
exactly.
I understand, Your Honor. I just like to complete the 2 work days and continue to continue the program.
Then let's do a good job at it. I get it that it's hard and there are difficult circumstances you got to go through, but you're going to have to put your best foot forward.
Correct.
Get as much as you can out of it. It may not be great, but you got to do it. So let's do it well as opposed to just doing the minimum. All right. All right. I will accept your plea. I do find that you've given me a proper factual basis for it. The other allegation is that you failed to provide proof of counseling. What happened there?
I have a counselor.
Your Honor, that's no longer an issue. I'm sorry. I forgot to mark that off for you.
All right, then I'll take that off right now. We won't have to worry about it. So I will accept your plea that you were unsuccessfully discharged from the batterers program. We will require you to do the 2 days of work camp in lieu of jail. That needs to be completed within 30 days. You'll need to contact Ms. Hill on Monday of next week in order to set that up so that she knows when you're going and what you're doing and where you're going. And then we'll have you re-enroll in the men's group and complete it successfully. I'll hold 5 days of jail in abeyance, meaning you don't have to do that if you successfully complete the batterers program, the men's group. If you don't, if you get discharged again, then I'm going to put you in jail for 5 days. Do you understand?
Yes, Your Honor.
All right, let's go ahead and do that then. Any questions that you have, sir?
No, Your Honor.
All right, that's all for today then. Thank you very much.
Thank you.
Technology.
And Mr. Fortier from the prosecutor's office. Mr. Dick, do we have a resolution of this matter?
No, Your Honor, we are just requesting a brief adjournment. And again, this is due to my circumstances that I've had the past few weeks here. Mr. Fortier and I began a conversation about this, but I never had the chance to follow up with him because of the family emergency. So I need to get back in touch with him to see if we have a resolution or what we need to do with it.
Would 2 weeks or so be a sufficient amount of time for you to make those arrangements?
One would be sufficient, Your Honor.
All right, I'm not quite sure how fast we can get it back in, but let me check.
December 4th be the earliest you can get on the docket.
The earliest I'm told that we can get you back on the docket is December the 4th.
Sir, I have a question. The interpreter in Spanish, please?
I'm sorry, Mr. Leyva, I'm having a hard time understanding what you're saying.
He is going to request an interpreter, Your Honor.
Yeah. Great.
Does he want Spanish?
Yes.
Yes, sir, please.
All right, let me see if I can work that.
Welcome to Language Line Solutions. Please enter your 6-digit client ID. For Spanish, press 1. For please enter your personal code. Please hold for an interpreter.
Thank you for calling Language Line Solutions. This is Jose, ID 393533. I'll be your Spanish interpreter today. May I please have your personal code?
39922.
How can I help you?
I'm sorry?
How can I help you?
I have a gentleman that I'm trying to arraign. This is Judge Hesselink. I'm trying to work on a status conference. He is in the Chippewa County Jail and requests a Spanish interpreter.
Okay, Governor, go ahead.
All right, Mr. Dick, do you want me to repeat from the beginning, or where would you like to go from here? Go ahead, sir. Yeah, hang on, Mr. Dick.
Le habla su intérprete de hoy. Señor Dick, ¿quiere que comience desde el principio una vez más o que continuemos desde donde nos quedamos? I cannot hear her, sir.
You're gonna have to speak up.
Tiene que hablar más fuerte.
Oh, sí, ya lo escuché.
Hable más fuerte.
Sí, lo escucho.
I'm sorry, sir. I cannot understand him.
Mr. Interpreter, could you ask him to come closer to the microphone?
Señor, ¿puede acercarse al micrófono?
Pues está diciendo que me escucha mejor.
He has moved forward. Can you ask him to speak loudly now and see if you can hear him?
Señor, por favor, hable fuerte y claro para que le podamos entender.
Ok, sí, está bien. Solamente quería saber qué es lo que están diciendo porque no entiendo todo.
Okay, I can't understand him, sir. I'm really sorry.
Would you, can you ask him to come closer to the microphone and speak slowly and loudly?
Señor, por favor, acérquese al micrófono, hable fuerte y despacio para que le podamos entender.
Ok, estoy cerca del micrófono. Lo que pasa es que está arriba del televisor y no sé, se escucha mucho eco.
The thing is that this is close to the TV, so there's a lot of echo.
The biggest issue that I have is whether you can hear him as the interpreter and can tell me what he's saying, because I'm not worried about him having echo.
No, I was interpreting, sir. That's what he said.
All right. So are you good now as the interpreter?
Not really, but we can go ahead.
All right. We'll do the best we can. Mr. Dick, I understand that you want an adjournment. Is that correct?
Yeah. Yes, Your Honor.
Entiendo que usted quería un aplazamiento. ¿Es correcto?
No, yo no quiero ningún aplazamiento. Yo ya casi tengo 3 meses aquí por algo que no han presentado ni un cargo, ya no quiero estar. Migración no me deja salir de aquí.
Señor, hable fuerte y despacio.
Ok, le estoy diciendo que tengo casi 3 meses aquí. No quiero ningún aplazamiento porque no me deja salir migración de aquí. Quiero que me cierren este caso porque ya tengo...
I have been here already for 3 months.
Mr. Leyva, your attorney has had a medical emergency in his family and has been unable to talk with the prosecutor.
Señor Leiva, su abogado ha tenido una emergencia médica con su familia y no ha podido hablar con el fiscal.
He requests an adjournment to do that so that he can get a deal for you.
Él pidió que un aplazamiento para que él pueda hablar con él y así poder conseguirle un acuerdo.
What else do you want me to do?
¿Qué más quiere que haga yo?
Pues yo solamente quiero que me terminen esto porque me tienen arrestado aquí desde el 26 de agosto. No me dejan salir. Supuestamente que termine este caso no puedo ni atender mi caso con inmigración. Tengo permiso de trabajo, pero me quieren tener retenido aquí.
Señor, hable fuerte, despacio y claro.
Le estoy hablando claro. Le estoy diciendo que quiero que terminen este caso porque ya tengo casi 3 meses aquí. Me han aplazado 2 veces la corte. Yo entiendo que no estaba el abogado, pero inmigración no me deja salir, ICE no me deja salir de aquí. Y mi madre está enferma. No puedo seguir aquí porque está ya preocupada por mí.
Finished already. I've been to court already twice. I understand that the attorney is not there, but ICE is not letting me out of here.
I can't help what ICE does.
Yo no puedo ayudarle con lo que hagan los servicios migratorios y de aduanas. Ay.
Ok, entiendo eso. Pero yo incluso pagué un bono la primera audiencia que tuve para que me ayudaran a cerrar este caso. Porque no me dejan salir de aquí.
Okay,
Y
I
yo tengo,
understand, but I actually paid a bond on the first time that I had a hearing about this case.
If you paid the bond on my case, then he can be released on my case. I can't help it if ICE is keeping him detained.
Si usted pagó una fianza en mi caso, entonces usted puede ser puesto en libertad por mi caso, pero yo no puedo hacer nada si los servicios migratorios y de aduanas lo están manteniendo ahí.
ok, entiendo eso. Solamente quería saber si me pueden cerrar este caso, porque mi mamá está enferma.
Okay, I understand that. I just wanted to know if you could close my case.
The answer to that is no.
Y la respuesta a eso es no.
Mr. Leyva, if you would, please, later today, call me at that number that was given to you a few moments ago.
Señor Leiva, si gusta, más
That is-
tarde el día de hoy
that is-
puede llamarme a ese número que le dimos.
And I will be able to more thoroughly explain your circumstances and why ICE is able to still keep you there.
Y de esa manera podríamos hablar más acerca de eso y de por qué ICE sigue manteniéndolo ahí.
Ok, le entiendo. Lo que le quiero decir también es que si no se han presentado a ponerme cargos, ¿por qué no cierran el caso? Yo le estoy comentando y por favor quiere que le diga eso a usted también, que mi mamá está enferma. Porque no puedo salir de aquí, no puedo cerrar este caso, ella se preocupa más. Tiene presión alta, tiene Parkinson. O sea, ella está muy enferma.
Señor, perdón, pero ¿puede acercarse al micrófono y hablar fuerte, por favor?
Le estoy diciendo que entiendo eso, pero él quiere hablar, pero a mí me urge cerrar este caso porque mi madre está enferma. Mi mamá tiene Parkinson y sufre de presión alta. Está enferma todos los días porque está preocupada porque no sabe cuándo me van a sacar de aquí. Y yo no he cometido ningún delito.
I understand that, but I need this case to be closed already because my mother's sick. She has Parkinson's and high blood pressure, and she's worried because she doesn't know when are they going to release me from here, and I didn't do any crime.
All right, we're going to set another jury status conference for December the 4th at 9 a.m. via Zoom to allow Mr. Dick time to resolve the case.
Okay, entonces vamos a poner esto para otra conferencia de estatus de jurado el día 3 de diciembre para permitir al señor Dick tiempo suficiente para poder resolver este caso.
Su señoría, le tengo una pregunta. Si el oficial que me está acusando no se ha presentado a ninguna corte, ¿por qué sigue abierto él? Él me retuvo supuestamente porque tenía una identificación falsa. Porque en la tienda me dijeron que estaba...
By answering, why is the police officer who was accusing me never appeared in any of the court dates? He said that I had a fake ID.
Your attorney will be able to help you understand that.
Su abogado es quien puede ayudarle a entender eso.
Okay.
That's all for today. Thank you.
Eso sería todo el día de hoy. Gracias.
Thank you, Your Honor.
Thank you, Mr. Interpreter. Appreciate your assistance.
No problem, sir. Thank you for your services. Have a great day.
You too. Who do we have from Roscommon County Jail, please?
Marshall Hafner, sir.
All right, thank you. We'll call your case next. This is the state of Michigan versus Marshall Hefner, file 25-43785-ST, set for a status conference. Mr. Hefner, looks like you're charged with driving with your license suspended. Do you have an attorney to represent you, sir?
Sir, I've tried to be in contact with my attorney and I've had no luck thus far.
Who is your attorney?
His name is Mr. Pfeiffer. He's out of Alpena.
What have you done to try to contact him?
I've left messages. My mother is my power of attorney at the moment, and she's left messages. I have sentencing on the 1st. And I don't know, the guy is just busy. I don't know why he hasn't been back in contact with me, but.
Well, my notes from October the 15th indicate that we adjourned from that date to today's date to give you an opportunity to contact Mr. Pfeiffer. I don't know what to tell you if you haven't been able to contact him in a month.
I know, sir. Yeah, no excuse.
Have you been incarcerated for that entire time?
I have.
And are you incarcerated in Roscommon for that entire time?
Yes, sir.
All right. Is he your attorney on the Roscommon County case that you have?
He is, sir.
And you say you have a hearing coming up on the 1st for sentencing?
Yes, sir.
We still open on the 4th?
Yeah.
All right. I'm going to give you one last opportunity to get a hold of him. I have a time slot available on December the 4th, which would be the Thursday following your Monday, December 1st sentencing. So you should be able to contact him on the 1st, if not before then, and say, hey, I've also got this other case in Gaylord. I need you to file an appearance and cover for me, or he needs to tell you, sorry, I'm not doing that. And then you can tell me you got to go on your own or you got to get another attorney.
Okay.
But
Yes,
at this point, go ahead.
No, I was just agreeing. Yes, sir.
Okay. So that'll give you about as much time as I can extend it out. After that, we got to start moving things forward and getting things done. So talk with him about this case and how to get it resolved so that he can give a phone call into the prosecutor's office. Otherwise, you're going to be either trying to get your own attorney, a different attorney, or you're going to be doing it on your own, but we're going to make some strides to resolving the case after that. All right.
Okay.
So December the 4th, 9 a.m. via Zoom. All right, sir?
Yes, sir. Thank you.
All right. That's all for today then. Thank you. State of Michigan versus Ronald Foster, file 25-44080-SM. We have Mr. Foster with us. Mr. Foster, you're still on mute.
Just asking about mute.
There. All right, I can hear you now, sir.
Thank you.
Mr. Brown, is this your case?
It is, Your Honor.
All right, Mr. Foster, you're charged with assault and battery. Today is the day for a status conference. Mr. Brown, do we have a resolution of this?
We do not, Your Honor. Mr. Foster has requested a trial in the matter.
All right. I assume that means a jury trial, or do you want a bench trial?
Jury trial, Your Honor.
Mr. Fortier, would this be a one-day trial?
Yes, Judge. And I don't believe there's going to be any pretrial issues.
All right, we'll schedule a one-day in-person jury trial. We're going to need criminal jury instructions, one set. So the attorneys will need to get together on that. And that will be 1 week in advance. Witness and exhibit lists, 1 week in advance. Mr. Brown, do you anticipate any evidentiary issues?
No, Your Honor.
If there are, again, 1 week in advance, we'll set a final status conference 1 week in advance. And if anything comes up, we'll deal with it at that final status conference. Mr. Foster, putting together a jury trial requires the court to put a number of people in the community, usually a group of about 30, in the courtroom to get ready for your case. That's a lot of work and a lot of taking people outside of their jobs and doing things. And I tell you that not because it's a problem, but because it simply requires a lot of preparation to do that. So because of that, I do not let people plead at the last minute, because we would have all of those people coming into the courtroom for no reason if you were to enter a plea at that time. So I say that to say this: your last opportunity to change your mind and to enter a plea would be at that final status conference 1 week in advance of the jury trial. That's not telling you that you have to change your mind. I'm simply giving you information that that's the last opportunity to change your mind. If you still wish to have a jury trial, it is your right to have a jury trial, and we would be happy to put that together for you. So what I want you to do is, between now and that next status conference that we have, is talk with your lawyer a lot about what your case is, what the facts are, what the law is, and what the likelihood of success is at trial, and whether or not you should enter a plea. If you believe that the jury trial is the best thing that you should do and can do, then we will certainly have a jury trial. So I just wanted you to be aware of those things. Do you have any questions for me, sir?
No, thank you. Thank you. Thank you though for letting me know that.
Yep, that's all right. Mr. Brown, is there anything else that we can do today?
No, Judge, thank you.
All right, so we'll set a status conference a week in advance of the jury trial. Notice will be sent out. Mr. Foster, I have your address on Kellogg Drive in Gaylord. Is that correct?
6150.
Yep.
Yes.
All right, we'll send the notices out there. If you don't get a notice in the next week or so, call your lawyer to make sure nothing has changed.
Yes.
That's all for today then, sir. Thank you very much.
Thank you.
Next matter is the state of Michigan versus Jenny Scott, file 25-43732-ST. I do see Ms. Scott is with us. Mr. Brown is here for the defense. Looks like we have in order to show cause for failure to appear for a jury status conference on 10/23 of 25. Ms. Scott, there's an allegation made against you that you failed to appear for a status conference with the court on October the 23rd of 2025. What happened there?
I honestly, I didn't get any of the information of it, and I was working, and I worked third shift, so that was my fault. I'm sorry, I wasn't aware of it.
I have a notice that went out to 931 South Otsego Avenue in Gaylord on September 22nd. Is that your current address?
That's the local Otsego DHS office, and I haven't been there in the last week or two to pick up any of my mail. I've been I got a new mailing address at the PO box DHS helped me with, and I'm still working on switching everything over there.
Where do you want us to send your notices so you don't get yourself in trouble anymore?
Thank you. It is 289 West Commerce Boulevard. PO Box 32.
All right, I'll have our staff change your address to that you just gave us so that you get your notices in the future at a proper place.
Thank you.
If you don't get your notices, you need to be in contact with your attorney so that he can make sure that you will show up when you're supposed to show up. The court can only assume that you're intentionally not appearing if you don't appear. So if there's some issue going on about notice, the only way that we would know that is if you have contact with your attorney and you say, hey, I didn't get those notices, so that he can then tell the court and it can excuse your failure to appear, or better yet, you to show up even though you didn't get the notice because your attorney would tell you. Does that make sense? Ms. Scott, does that make sense?
Hello?
Yes, can you hear me now, Ms. Scott?
Yes. Yes,
All right.
thank you.
Did you hear my request?
And it does make sense.
All right, good, thank you. All right, Mr. Brown, do we have a proposed resolution of this matter?
We do, Your Honor. I just sent this morning, because that's when I received it, certificate of insurance for Miss Scott. The offer would be to plead to a civil infraction. I did speak with her, and that is the way we're going to proceed today.
The civil infraction being?
No proof of
No
insurance.
insurance.
No proof. All right. And I assume that's okay with you, Mr. Fortier?
Yes, Judge.
All right, Ms. Scott, the attorneys have said that they think that there's a way to resolve this matter by you admitting to a civil infraction, which is typically resolved by a fine of $160, and the criminal case would then be dismissed. Is that what you want to do?
Yes, sir.
If you do that, you would not have the criminal rights that you would have at a trial. You'd be giving up your right to have a trial by a judge or a jury, your right to have your attorney represent you, the right to see, hear, and question all the witnesses, the right to present your own witnesses and evidence, and to get an order from the court called a subpoena to require those witnesses to appear and testify. You'd be giving up your right to testify yourself or to remain silent and not have that silence used against you. You'd also be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, you'd also be giving up your right to appeal. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No.
Do you understand that by admitting to a civil infraction and paying the fine, you would be giving up all of those rights?
Yes, sir.
Knowing that, is that still what you want to do?
Yes, Your Honor.
All right. Would you raise your right hand so I can swear you in? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, go ahead and put your hand down. Has anybody promised you anything other than this plea agreement to get you to plead today?
No.
Has anybody threatened you in any way to get you to plead today?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes.
The civil infraction made against you of no proof of insurance would read as follows. It would say that on or about May 14th of 2025, within Hayes Township of Otsego County on M32 near North Town Line Road, that you were stopped by the police and you failed to provide proper proof of insurance at that time. Is that correct?
Yes, Your Honor.
All right. Have you now got proper insurance on your car?
Yes, I do.
All right. It appears to me that you've given me a proper factual basis, so I will accept that civil infraction. The standard fines and costs for no proof of insurance is $160. Can you pay that within the next 30 days?
Yes, Your Honor.
Do you need the number to call for the court to set up that payment?
Yes, please.
989-731-0201.
Thank you.
Go ahead and make that payment and the case will be done. Thank you, ma'am. That's all for today.
Thank you. Have a good day.
You too.
The Honorable Judge Simpson presiding.
And good morning, folks. Court does call the case of Far Properties versus Janine Heim and Mitchell Wilson.
Good morning, Your Honor. May it please the court, Keith Nathanson, P41633, appearing on behalf of the plaintiff, Farha Properties.
Heim or Wilson? They are not here. If you'd like to take a default, raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God? Go ahead, sir.
I do, Your Honor, yes.
All right. What do you wish to do with this?
We'd request that a default judgment of possession be entered. Rent to retain is $2,700 per month. There is currently owing $5,400 in rent, including the current amount of rent for the month. In addition, there is $26.58.26. I apologize. I'm reading from my other monitor to the left of me here. $26.58.26 for the water bill. So that is a total of $8,058.26 plus court costs with a 10-day notice.
Okay, what's the total amount you're asking for, inclusive of court costs, sir?
Oh, I apologize, Your Honor. Hang on one moment. The staff usually does this for me and did not this morning. Total rent to retain $8,183.26.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Very good. I'll have my office submitted immediately. Thank you.
All right, thank you. Lori Anderson versus
I have one more
Armani
matter.
Lyman. Yes, I just called it. Lori Anderson versus Armani Lyman.
Yes, you did.
Hi.
And again, may it please the court, Keith Nathanson appearing on behalf of Lori Anderson, who's also present in the place instead of Sam Jarbo, the attorney of record.
Ms. Lyman, are you here? You are here. Okay, the problem with this case is that I'm not sure why we have this case. There's already a case pending, a non-payment case that's pending. This is a new non-payment case. Ms. Anderson submitted a dismissal after we had gone through on the record that I wasn't going to dismiss it because Ms. Lyman objected to the dismissal. So I'm not even sure why I have this case. So the only thing that I can do on this is I'm just going to set this for, it's for a decision on the other case, which is inclusive of rent, right?
That is correct.
I'm just going to adjourn this case to November 18th, 2025 at 9 a.m. That's an in-person hearing, just to have it tag along with the other case. Again, not understanding why I have two. Thank you.
Thank you.
All right. Thank you, Your Honor.
Sue Morris versus Patrick Myers.
Good morning, Your Honor. Ryan Sweeney appearing on behalf of the plaintiff, Sue Morris.
Patrick Myers. All right.
Yes, sir.
This is a termination case.
That's correct, Your Honor. There's no written lease. It's a month-to-month tenancy between mother and son.
Okay. And Mr. Myers, what's your position on this?
I'd like to contest it and request a trial.
What's the basis of your claim? I have to have something that I'm going to try on the case.
How much time do we have, sir? Long story short, my grandfather years ago agreed to help me purchase a house. During the search, he got dementia, went downhill fast. My mother was able to trick him into putting the name into her house before we closed.
Okay, I'm not gonna go into all that right now. Here's what I'm
Yes,
gonna do. I'm gonna set it for a final settlement conference, November 18th. Is that right? November 18th, 2025, 9 a.m. That is an in-person hearing, so you must come down to the court. I'm going to require that you file a written answer to the complaint. You're to file that by the 14th of November.
I would request time to be able to get an attorney, sir. I found out about this last Wednesday.
That will give you more than a week to get an attorney on this, sir. I'm not setting it for trial, but you need a written answer by the 14th.
Written answers. Okay, so okay, I'll find an attorney and I'll get that for you.
Thank you.
Thank you.
26 Wabash LLC versus Jayla Ware.
Honor, Vaso Karpatsakis on behalf of the plaintiff.
Yes, I'm here.
All right, Ms. Ware. All right, what is your claim inclusive of court costs?
3 months of unpaid rent at $1,500 a month, $44.90 for the process server, and $135 filing fee for a total of $4,679.90.
Ma'am, how were you intending on getting this paid?
I just got my car back together, so I just started back going to work.
I'm sorry?
I said my car just got back right. I'm just now going back to work. So maybe in the next paycheck. And the rent is not $1,500 a month, it's $1,400 a month.
I can't hear you, ma'am. You need to turn on your camera, please.
You hear me now?
I can hear you. You're very muffled.
Okay, is it better?
Not much better. What I heard, and I think I heard everything, is that you're just going back to work?
Yes.
Have you arranged anything with the landlord regarding payment of this?
No.
All right. You probably need to reach out to them. Have you sought any assistance in the case, either from Hawk or from SER or anything?
Yes.
You have?
Yes.
Which one?
Hawk.
You called Hawk?
Yes. I just got the court papers last week.
What I will do is I'll give her the week adjournment. You'll have to file, if there's some assistance and you have a tracking number, you'd have to file that with the court by next Wednesday. I'll adjourn this to November 14th, 2025 at 2 p.m. That is an in-person hearing. So it'll need to be down at the courthouse.
Thank you, Your Honor. Pleasure to meet you.
Thank you, sir. My next. Court does call the case of Augusta Woods versus Shalisa Floyd.
Mr. Land.
Mr. Landman? Augusta Woods? Okay.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of Augusta Woods.
Shalisa Floyd? Is there a Shalisa Floyd? There is no response. If you'd like to proceed, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. Your Honor,
Go ahead,
with respect to Ms. Floyd, based on my client's books and records, The rent to retain is $694.64. Costs are $179 for a total of $873.64. We'd requested a default judgment enter in that amount with a writ date of November 17th.
Judgment to the plaintiff, that's by default for possession, redemption amount, and the amount requested with the writ issued 10 days. Augusta Woods versus Rachel Lindbergh and William Lindbergh.
Daniel Landman for the plaintiff.
I don't have either first name.
Rachel Lindbergh, William Lindbergh. We have no response. You may proceed.
Thank you, Your Honor. Based on my client's books and records, the rent to retain is $1,643.40. Costs are $218 for a grand total of $1,681.40. We're requesting a default judgment for possession only with the writ date of November 17th.
Judgment to the plaintiff by default for possession, redemption amount, and the amount requested, writ issue in 10 days. Augusta Woods versus Eric Roden.
Good morning, Your Honor. This is Teresa Robbins on behalf of my husband, Richard Robbins. He works evenings, so.
Eric Roden and Richard Robbins Jr.
Yes.
All right. Where is this? That's your husband?
Richard Robbins. Eric Roden no longer lives in the home.
All right. Okay. And Mr. Robbins is at work? Is that?
No, he works evenings, so he's asleep.
Okay. Well, you're not on the case, but I'll let it go ahead. Mr. Landman.
I'm sorry.
Your Honor, my client is currently showing a balance of $2,610.74 plus cost of $218 for a total of $28,2874.
Ma'am, how are you guys intending on getting this paid?
We intend on paying approximately $1,100 next week, and then the following week having it paid off on the 19th.
So $1,100, what day are you going to pay that?
We get paid next Wednesday, which is the 12th.
All right, I'm going to put in the file $1,100 by the 12th. I'll adjourn this out 1 week to the 14th, 2025 at 1 p.m. All right.
Okay.
I suggest that you contact maybe plaintiff's counsel's office or your landlord, see if you can arrange some type of conditional order, dismissal, or other arrangements to pay the balance.
Okay, sounds great.
All right, thank you.
Thank you. Bye-bye.
Augusta Woods versus Patrice Tishma and Phyllis, is it Terwillinger?
Daniel,
go ahead.
Yes, Your Honor. It looks like Ms. Tishma and Ms. Terwilliger are not present. Therefore, plaintiff.
That is correct.
Plaintiff moves for the entry of a default judgment for possession only. Based on my client's books and records, rent to retain is $1,511.83. Costs are $218 for a total of $1,729.83.
Judgment to the plaintiff by default for possession, redemption amount, in the amount requested, writ issue in 10 days. Beal Properties versus Courtney Goff.
Daniel Landman appearing for the plaintiff.
Courtney Goff, no response. You may proceed.
Thank you, Your Honor. This is also a non-payment action. Based upon my client's books and records, rent to retain is $1,530. Costs are $175 for a total of $1,705. Writ date of November.
Okay. Judgment to the plaintiff. That's by default for possession, redemption amount, in the amount requested, writ issue in 10 days. Beal Properties versus Emery Oaks.
Daniel Landman appearing for the plaintiff.
Emery Oaks.
Present. Hello.
All right. What is plaintiff's claim in this case?
Your Honor, plaintiff is claiming back rent of $3,095, costs of $175 for a total of $3,270.
Sir, how are you intending on getting that paid?
I would like to propose a payment and repayment schedule. I am able to submit a $500 payment today, And on the following 15th of every month, I would like to pay $1,000 along with paying the rent originally agreed upon by the 30th or 31st of the month.
All right. Well, here's what I'm going to do. You'll either need to contact plaintiff's counsel or contact your landlord directly to see if that payment plan will work for them.
Okay.
I will adjourn this out for you to do that to the 14th, 2025 at 1 p.m. You're to pay the $500 to them today. If it's not that, the date that I just set is an in-person hearing, so you'll need to come down to the courthouse.
Understood.
All right. Thank you.
Thank you.
Court calls the case of Beal Properties versus Jose Campos. And Jose Silva and Gabriel Silva.
Your Honor, the court hopefully has in its possession a proposed dismissal. Plaintiff moves to dismiss without prejudice.
Okay. All right. I will dismiss that case. That's without prejudice. We don't have it, though, do we? Okay. Beal Properties versus Jennifer Hazel Baker Rollinson and Casey Field. Hazel Baker Rollinson or Field, neither are present. You may proceed.
Thank you, Your Honor. Plaintiff moves for the entry of a default judgment for possession against these tenants. Based on my client's books and records, rent to retain is $4,414. Costs are $214 for a grand total of $4,628. We'd request a writ date of November 17th.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested with a writ issue in 10 days. Investors Realty Group versus Alexandra Streety.
Daniel Landsman appearing for the plaintiff.
I think I see Miss Streety here. Okay. What is plaintiff's claim in this case?
Your Honor, plaintiff is showing a balance of $3,674 as well as costs of $175 for a total of $3,849.
All right, Miss Streety, how are you intending on getting that paid?
Hi, I am working with SOS and I applied with SER, which is pending. I was off of work for a surgery, so I'm getting actual checks. I have just about $900 I could pay today. I was emailing with Colleen Kennedy yesterday because SOS said that my tub has to be fixed before they are allowed to do any assistance. My tub fills up in 2 minutes and it takes over an hour and some change for it to drain.
Got it. So there might need to be some repair issue.
Yeah, and SOS said that until the repair is finished, they can't provide any payment.
All right. And Mr. Landman, if you could have your client check into that tub issue.
I'm gonna submit the through the portal. I guess you submit it. I was kind of confused when everything switched over from my landlord to this from John, and John was aware of the issue, and I talked to him about it multiple times. But I don't know if he passed that on to them, but they are now aware because I messaged them.
So what I'm going to do is I'm going to adjourn this to November 14, 2025 at 1 p.m. That's an in-person hearing. You'll need to come down to the courthouse. Get the $900 paid to the landlord today. Okay.
Okay.
And there's a form that came in your packet called a rental assistance form. You'll need to fill that out, put your SER tracking number on that, and submit that to the court by next Wednesday.
Okay, will do.
All right.
All right.
Hey,
thank you.
Thank you.
Right. Bye.
Manchester Manor versus Joyce Schroff.
Daniel Landman appearing for the plaintiff, Your Honor.
Schroff, no response. You may proceed.
Thank you, Your Honor. Based on my client's, well, actually, Your Honor, I don't know if we have submitted it. I believe we may have. Faxed in November 6th at 1:30. There is a proposed consent judgment terminating Ms. Schroff's tenancy. The consent judgment provides that her tenancy may continue as long as she refrains from allowing her son, Thomas Pratt, to reside with her or visit within the community. She is also comply with all community rules and regulations and pay costs. The proposed consent judgment was faxed yesterday together with an advice of rights.
Okay, we don't have that yet, but
I can read.
what I will do, I will grant a judgment along those terms for possession. And then once we receive it, I'll sign off on it. Understanding that.
I will email it to Ann as well as the defaults today so that.
All right.
Judgment.
All right, very good. Thank you. Court calls the case of Showcase Investments versus Daniel Boyd.
Daniel Landman appearing for the plaintiff.
Boyd? Oh, she's here. I see her.
She's here.
Okay. What is plaintiff's claim in this case?
Your Honor, plaintiff is showing a rent arrearage of $9,003.76, as well as costs of $175 for a grand total of $9,178.76.
All right, Ms. Boyd, how are you intending on getting that paid?
I have submitted an application with the SER. I also have been in contact with Hawk.
Okay.
When the balance was lower, I had contacted Hawk and they said I needed to have a eviction notice in order for them to help.
The state of Michigan of due in the public defender's office, due to the Indigent Defense Commission. There are staff, such as an investigator, that work for the public defenders. I know there's only one over there, but I kind of concerned as to why why in 2 months nobody can come and say, "Hey, Judge, I needed an expert. I hired one." So,
issue really came about as a more recent conversation between Mr. Beals and our office, and a review of particularly the body cam that he completed with my investigator.
okay. All right. So the investigator was involved and sat down with the.
Absolutely, yes.
Okay. And just a moment as I consider something else not yet brought up. There's something else I've noticed, but I'm going to mention because it's up to the parties. Mr. Carnes, your response?
Your Honor, essentially, I don't take a position on this. I do note we're not running right up against the trial clock and the defendant was out on.
Yep, I was gonna note those as well. So the trial clock hasn't necessarily triggered. That was one of the things I was making sure I understood here in the file. I know that he's not in pretrial custody. I can obviously say that, but
Rigoberto Gonzalez is also reset. Mr. Ham is not here. Do y'all know anything about that from the state?
Just the attorney has the flu.
Rigoberto Gonzalez. You don't know why that was. See, we have all these things said. Friday.
Something early in here, but she hollered out.
Okay, we're not getting anything done. That's Camilla LeBeau. Brent?
Yes, sir. Judge, she was reset from a couple weeks ago. We had come in and asked.
Where is he?
She's here.
Oh, it's Camilla.
We had asked the court to amend one of her bond conditions, contact with the complaining witness, because it's her son. The court wanted her to take a parenting class, which she has been doing. She is currently in week 4, I guess approaching week 5 of 12 with the Faith Tabernacle Ministries parenting class. She's been doing great work there, apparently, talking to the people there. And so we reset it today so the court could see that she has been taking parenting classes because
what does that do from, I don't.
The reason they're bringing this all up is this is a special needs child that has trouble with people controlling the child. And so I think she lost her temper during one of the uncontrollable moments, and that's what caused all this. And so we wanted her to take parenting classes to learn to deal with this situation.
Before disposition?
Before we gave her permission to be back around the child. Which, and I think the case may, once she does the parenting, we may actually dismiss it. We're discussing that. But right now,
how long is this going to take?
She has.
The last day will be December the 28th.
Okay. Next month?
Yes, sir.
Yeah.
Right.
It's a 12-week spread.
Yes, ma'am. Okay.
But we've had calls from the grandmother asking, well, please let her back in because they're having trouble controlling the child. So we're in that little quandary of she hasn't completed what she needs to complete, but
she's completing it.
She's working on it.
The one thing she can't do is speed up time.
The only solution I could think of is if we make sure someone else is present during the times that she has the child. Make it like a supervised visit. That way we have somebody there that if things.
I think weaning this relationship back into order is the way it's going to have to happen, one step at a time. But this is, taking those classes should be finished in December. Before then, what are you asking for?
Just we were reviewing, we just need her to be able to come get her son again because the school or the surrounding family is just unable to control him. And even his mom, the child's mom, Ms. LeBeau, is apparently, historically speaking, the only one that's been able to manage him with any degree of success. I understand the situation, but at the same time, everyone in the community around this child is begging for her to be able to have her son back.
Anything else be something?
I suggested that if we're going to do that, that it be like supervisor, somebody with her, another adult with her, to make sure that if there's something that looks like it's going wrong.
Take more than just half the population of the planet to be eligible to do that. We've got to figure out who would be a responsible person that would chaperone.
mom, her resident has been watching him. So
Where are we in relationships? I mean, yeah, this has got to be somebody who's going to be able to do chaperoning here in an objective fashion. Yeah, I mean, not overlook issues that might come about because she still has two months to go on kind of retraining or composure, I guess, is what we're talking about.
Yes, sir.
I don't have a problem. But whatever is in the best interest of the child is foremost. Is that in the best interest? Parties seem to agree.
Yes, sir.
Maybe y'all know more about it. I'm looking at this probable cause affidavit. Probable cause affidavit is disturbing.
Yes, sir.
Because you disagree with what the investigators concluded. That's the problem right there. I mean, it's either we either need to have righteousness, that is honesty about it all in dealing with this, but you disagree with what the experts concluded. That's a problem because I've got to be able to trust your honesty in dealing with this. If you made a mistake, you made a mistake one way or the other. Fix it and move on and be the best person you can be. Yes. I mean, you're not here alone on this planet. You've got a child that's dependent on you. Okay. And you've got to be a role model, an example, such a good example, not bad example. But first thing right out of the box is honesty. That's an issue that bothers me. That's not concluded. That's a fact finder issue. If she wants to go to trial, but it's a dot that's not on the I. It's T that's not crossed. It's got to be resolved somehow so that we can move on. And because getting this straight and correct is part of fixing this mess here. And I mean, the grand jury indicted one way, and she insists it's not that way. So that's going to be a fact-finding issue before that's resolved. Because I'm not going to be granting some relief. But I think it's fixable, is what I'm saying. I'm not, but we can't start out with a disagreement on the facts because we're talking about a child's best interest and your rights under the law. But that's a big deal. What really happened and how do we, because until that can get really admitted to and resolved and concluded, how do you fix the problem? I think it's fixable. The way I'm reading it, either way, it's fixable. It's got to get straightened though. A mistake was made according to the grand jury, and you disagree with what the grand jury concluded and what the police say. And until that gets resolved somehow for everybody's satisfaction, the child isn't going to have. You're not going to have, independence with the child. And I'm all for getting the unit back together. We got to do it correctly,
Is the state suggestion amendment?
That's for y'all. Y'all are the parties on this. I'm just looking at it as the mediator here.
Yes, sir. I just want to make sure that it's in the order that the grandmother be present at all times.
It's just because it was a bond condition set by the courts.
Yes, sir.
Okay. Your relief is, as requested, is granted on.
That's all.
What's the next event?
Her completing.
She's got until December when?
December 28th would be my last class. Then they're gonna give me a.
You said it till January and we can present her completion.
All right, first week in January. Thank you very much. Yes.
Make sure I get her name and address.
Yes.
The first one, Mr. Butler's case, Mr. Nelson sent me the doctor, sent me an email, and didn't want to infect us all. I appreciate it. And Drug America, the DA's office hasn't done the refile yet. So they're working on that, from what I understand. They're both with quick resets.
Then we have, I had Diane Rubin. John? On Diane Rubin?
They didn't bring her over there on it. This is a case where, well, we see.
There's some problems that we're unable to get.
Yeah, it wasn't anything.
But is that going to be necessary? I see the note. The
That's fine. That's just the state.
What do you know about?
They were going to dismiss one and plea on the other. And she was revoked her probation and they gave her 5 years. And so we're trying to get her to accept the 5 years on one of the new cases. Well, she won't. It's just, well, the bond says she's competent, but she won't. She won't take it.
You can't.
Well, you can't make it. I know. That's the issue I have.
But what's the competency status?
Honestly, we're competent. And the last hearing, we said she's competent. So exactly. It's not up to us, but I can't get her to say I'll take the.
Okay, well, that's okay.
So I guess she's just sit on the phone.
It's her choice.
I mean, that's all we need.
Do we need to bring her in here so that
she's not here?
Do we need to bring her in here when we can go in here?
I don't think so. I mean, it's not.
So that you can talk to her and then we put something on the record and then let her have her statements made. I think that's what's important.
Yeah. And you know what I'm here.
So we can make a record of.
That's fine. Just find another day and bring her over here. We can do that. Yeah, maybe
because it looks like you were trying to dispose of it. It seems like you think this might be a method that's in her best interest.
It is because she's already got 5 years.
She's competent. It's her choice, but let's put it on the record so everybody later doesn't.
No, I'm good with that.
Well, I wanted to do that, but my lawyer wouldn't let me.
Yeah.
You know.
Yeah.
Okay.
Because I'm trying to bring it in.
Bring her maybe in the afternoon when you're here, John.
That's Miss Rubin.
Do you have
Kaylin Hicks is on the desk. No, okay. I gotta go get on. I gotta go put it together. On Kaylin Hicks.
What's the motion I'm trying to do? Approval.
Where's Kaylin Hicks?
These are their study. I'll need Robbie's over.
You did.
Hicks, please. Thank you.
Mr. Laird's case.
The proposed orders.
Why are you bringing me into this? I'm an investigator. I got one.
What are you asking?
Dr. House will be an expert witness. I need to pay.
Why'd you? Are you, is he indigent then?
Oh, he's indigent now. I mean,
why did you choose? I've got Dr. Rapon, who was a licensed psychiatrist.
Tom just treated him.
So what? So what is that? You're asking for $5,000.
Right.
The taxpayers kind of are into this court.
We're going to have a fair trial.
You know, Dr. Rapon is a licensed psychiatrist.
Well,
I mean, he is the most renowned man.
It's not a competency issue.
It doesn't have to be. He's a licensed psychiatrist. What are you asking for? It's for mental health. He's a mental health expert.
It's asking for him to be evaluated, particularly for 2 reasons. One is potential mitigation evidence of punishment. The other is to assess the voluntariness of the statement/confession that he gave to the police, and whether he was mentally capable of knowingly and voluntarily.
But Dr. Rapon will be appointed to handle that.
As a defense expert?
He's an expert all the way around.
Well, I want an expert for the defense, not something that
he's indigent, right?
Yes.
Okay. He is approved by the court as a fair and independent licensed psychiatrist, and he will make the choice.
But is he a defense expert or is he an independent?
He's going to give whatever answer that is accurate. This is a science. He'll give whatever is the answer that's accurate.
But I need a defense expert that I can consult with.
You can do that. That's what he does.
Information will be confidential and attorney-client.
He will have to do that. He's not my psychiatrist. He doesn't work. He doesn't confide in to me his decisions or for everyone to know about. But he and I don't have a special relationship on this. He doesn't confide to me. He is appointed He is the psychiatrist that I appoint in indigent cases when it is necessary.
As a defense witness.
It doesn't matter what it is.
My point is, I need somebody that I can rely on to have.
When a defense asks for competency evaluation, I appoint, they are requesting it and I'm giving it to them.
This isn't a competency. I believe him to be competent. It's not a competence question. Somebody, I need a defense.
He's appointed,
expert.
he is the one appointed to help you on this. If you have a problem, you let me know.
Just to be clear, he's not to share information. This is a defense expert. He's not.
I believe he understands that. I don't think he shares information once he is hired and handles that. He's done this long enough to tell.
Well, I understand. Normally, when he's appointed, it's an issue of competency or something that is, available.
Because
we're doing it.
It's doing it. It's a request, but I am finding that that's the right thing to do. And then so he kind of works for me to help me make my competency decision. This is not my decision to be made. I'm not going to be the arbitrator or the decision maker and the fact finder. You want a jury, I guess, to make it.
Well, it's just, as I said, it's a question, first of all, mitigation. And then secondly, as far as the issue of voluntariness of the statement itself.
Dr. Prapon testifies, not often, but has testified for both sides in cases. That I didn't, they hired him, it's not me.
Well, just for the record, I would request that we have Dr. Hamza, since he is familiar with the defendant. I submitted.
I disagree. This is, he's indigent. He gets a competent man, and Dr. Ed Grapon, as you know, was leading psychiatrist here and was the man that was used in the James Byrd trials. And that was a worldwide trial, and he was the person who testified in those cases. And I find him to be fair, impartial, and most competent. That's what you're asking for. Plus, it's indigent, and this you're asking for at least $5,000. We can get somebody as competent that does not cost the taxpayers unfair amounts.
Okay, well, just to be clear, so the motion to have Dr. Hamza
is denied. You will be allowed as indigent. I will appoint Dr. Ed Grapon, the leading psychiatrist in this area. I think, knowing him. We'll contact him and tell him that he's going to be appointed, so that.
Well, I need to let him know the scope of the.
I understand you do. We're going to let him know so that you just don't come in off the street and he goes, well, "What are you doing?" And
I'm not here for a personal concept.
Yeah, but we'll, in other words, set the table for you. Okay, so that people.
And then as soon
have you ever worked with him before?
Yes.
Okay, well, he'll recognize you, right? That's not.
But as soon as that's done, I'll be ready to try it. I know it's held probably over 2 years, so it's a fairly long case.
Yeah. Who is the prosecutor on this?
I am.
Okay. He's working to move forward for trial. Okay. So we're going to put it on the trial docket. Yes, sir. Okay.
Yep. Okay.
Thank you. And let's let Dr. Rupert know about this case. And for Rice is going to. We're going to let him know.
Okay. I'll give him a call once you leave.
Hey, you're killing me on the lapel. There you go. Now you look great. Now you look.
Ma'am.
They're closed on Fridays, but it's almost all this, so don't wish to have nothing.
Okay. All right, what else? Is that it? Now it's Mr. Walker? Okay. We're going to take about a 5-minute break and come back. Everybody ready? Yes, sir. Yes, sir.
What do we do? No. We'll figure it out.
Oh, let me see the lawyers. Sure. Up here. This is good. Okay.
Have fun.
now people doing electrical work are getting paid more than they did a few years ago when we had the trial. He is not supervising, obviously, and owning his business, but yet he has the capability and experience to do work for others. And he promised to do that work somehow in his skill to pay this restitution back. This restitution is in the amount of over $1.1 million, $1.12 million or so. To remember, the victims in this case are the taxpayers of the Beaumont Independent School District. Over 100,000 people have been victimized, plus the education of the children that these monies would have gone into toward BISD and their administration of educating the children. That has been lost to some degree. So the children are suffering. This court has very little sympathy with the actions of the defendant. He was found to have stolen from thousands, victimized thousands of people here. And we are 3 years into this appeal. And up until last week, $7,900 or so had been repaid. And a condition of the bond that the court set on its revocation of probation to allow the appeal by the defendant to proceed. One of the conditions was to continue to reasonably pay on the restitution. And we talked, I'm not going to go over it again ad nauseum, but up until last week where another $2,500 came in, he had paid $7,900 over his term of probation, which was with the appeal of that trial, which occurred before 2020 and lasted a long time until we finally were able to get a mandate in 2022. But he had paid less than $8,000, and the court had noted over these years that is less than what he had spent when he did his 6 months required jail time as a condition of probation at the beginning of his probation, where he spent over $8,000 for goods in the commissary, which I found insulting and just an affront to the people. At this rate, at the payment rate that the defendant is making, it would take him 1,000 years to pay this restitution back, which is unreasonable. This court will find that that is unreasonable, especially in light of Mr. Walker's statements and representations from the outset of this case, that he has skills and capabilities and earning power that could be used to pay back the restitution. But yet he's on the 1,000-year plan. That's not acceptable. I open this door for Mr. Walker. It's open for everybody else. Everyone else on probation would go, can I have the Calvin Walker plan? I'd like to pay my restitution over 1,000 years as well. It's laughable if it wasn't so pathetic. And with 100,000 plus victims in this BI, who the taxpayers for BISD and the children whose education have been affected because of the $1.1+ million loss that BISD accrued because of Mr. Walker's theft. Then so many people have been victimized. And the state has consistently taken a stand on this one, that Mr. Walker should be in prison. And this court has had to wrestle with the promises being made by the defense on trying to help repay this restitution and its lack of actual payments to the satisfaction of this court, and the consistent mantra from the state, we've been telling you, it's not going to happen. And why do we continue to leave him on probation? Well, his probation has been revoked in a hearing where the court found that reasonable efforts had not been made. And the 1,000-year plan is not a reasonable effort, and it's not acceptable. And it's not going to open, I'm not going to allow that to open the door for everyone else who will say what's fair for one is fair for all. I want the 1,000-year plan too. So this court on its last hearing ordered, as the court was considering the revocation of his appeal bond and to place Mr. Walker into custody, awaiting the result of the appeal, which this court feels is forthcoming hopefully in the next few months anyway. The court proposed a solution, a short-term solution. The defendant has 3 properties, including the Lafitte's Landing properties in Port Arthur, and the Jefferson County Central Appraisal District appraised value is $160,912. There's a lot on Langham Street here in Beaumont. The appraised value is $2,034, and Brandon Street, there's an appraised value of $1,760. That totals an amount of $164,706 of value in property here in Jefferson County, Texas. The court is ordering as a condition of the appeal bond that Mr. Walker shall sign the quitclaim deed that have been prepared immediately, turning those properties over to the Beaumont Independent School District so that they can figure out on how that might be used. And it will be in lieu of cash. A property has its intrinsic value. It will be the defendant shall be given credit of the amounts that the appraisal district has given for those properties. The court will note that the Jefferson County Central Appraisal District's market values are always submitted to the property owners. The property owners, if they wish to protest those amounts, have their right and a process of doing that. Mr. Walker did not exercise any rights and privileges to challenge those values. Thus, they are accepted as his acceptance for those values, and the Central Appraisal District's value will be the amounts that this court finds are proper and shall be credited toward Mr. Walker's order of restitution. And I believe the defense has agreed to execute those documents today, and that will be ordered by the court as a condition of his bond on this appeal. Also, the defense has stated that they will be able at this time they will be able to pay at least $1,000 per month. And that, again, this court is not going to wait too long for that amount of reimbursement toward this restitution to get raised significantly. I'm going to allow that for the next 3 or 4 weeks. I'm going to have a hearing, and we're going to go through what we have done in the past, what are Mr. Walker's efforts and opportunities that he should be seeking and exploring every day until he can get a job and an income that he claimed he was capable of getting years ago when we began this probation. The court has had enough of the dunning that has been just talk and no action. And this court finds reprehensible a 1,000-year plan to pay off the restitution in what has been shown to be the actual payments using the math. Mr. Walker has paid toward this restitution. It's insulting and it's unreasonable. It had better change quickly. This court is going to give a little more time because of the $164,000 plus of value that the BISD is getting here today. But I don't believe Mr. Walker has any other properties to provide except for his homestead, which means he's going to have to get a job that pays more than what we have been receiving. This court is not going to allow the 1,000-year plan to be acceptable. What would be acceptable, that would open the door for every person on restitution to say, I would like the Calvin Gary Walker plan, the 1,000-year plan on paying restitution. It's laughable. It's insulting. It's not reasonable, and it's not going to be allowed on my watch. I will review this in 3 or 4 weeks, and if it is deemed your efforts are not reasonable and forthcoming and result in substantial restitution payments, then your bond is going to be revoked. It's what is reasonable is the test, Mr. Walker. And then your actions in the last few years have not shown reasonableness in a return on for the promises that you have made. The state, I'm going to take notice from the state. The state doesn't need to say anything. The state's very frustrated. We're all frustrated. And this is what this court finds today to be a method of temporarily keeping the status quo to try to get the 100,000 victims paid back some money that they are having to absorb by their taxes paid because of Mr. Walker's theft. And not to mention the children's education that has been adversely affected in BISD by the loss of $1.1+ million of assets that could have gone to the educating of children. In the sense that I don't have sympathy with the conduct that occurred that is underlying this judgment. It's a repulsive shame. It's a shame thing. And I understand the appeals are moving forward. The appeal on the revocation of probation is moving forward so that hopefully we're going to get a result here in a few months, because I believe the Court of Appeals moves expeditiously when they get all the when they get all the briefing in. I think the briefing's going to be done soon, John.
Correct, John. And I'd like to address the court just for the record.
Go ahead.
Okay.
And you're representing, again, Jonathan Landers, representing the defendant, Calvin Walker. Go ahead, Mr. Landers.
Thank you, Judge. So I guess for the record, I filed a memorandum related to a potential revocation of bond hearing we were going to have today. We objected to, well, number one, the current bond condition is that Mr. Walker would pay restitution. And according to the probation officer, he made essentially $8,500 in total payments since being on this bond. And
this, but once again, this is a bond that, $8,000 in payments over a course of now 3 years, right?
No, that was since May, since the revocation.
He hasn't paid $8,000 since May.
Total, I think the total amount of payments, and keep in mind, Judge, I'm including.
What's the total amount of restitution that's been applied? That's what
I need to subtract the $60 a month from that total. That's the total payments he's made, not including yes.
No, we have a figure.
Okay. I don't know.
No, listen.
But
hold on. The total amounts have been from supervision beginning on October 10th of 2022, when the appeal on the conviction was final. Total payments $9,945.
In any event, Your Honor, the defense today was simply going to be that he's been complying with the bond conditions. We also added in some briefing about orders of restitution more generally, and that they need to be definite so that a person has a definite understanding. We cited this Great House case. I think it was from the Houston Court of Appeals. There's not a lot of appeals on restitution, quite frankly, in which a defendant was ordered to pay $10,000 a month, and everybody seemed to agree that wasn't possible. And then the judge revoked him for not paying as much as you can, which was reversed. And then that as much as you can order found to be vague. And so we also objected to the turnover order and various things along those lines. But in an attempt to keep Mr. Walker out while he's on appeal so that we can prosecute the appeal properly. Also in an attempt to get these properties over to Beaumont, not having further litigation, Mr. Walker's in agreement to sign quitclaim deeds on those properties. We wanted more money, but we've agreed to the $164,706 credit towards restitution. And we also discussed prior to getting on the record that we need some sort of a definite number for Mr. Walker to work towards, and that's the $1,000. So my understanding is that we'll be changing the bond conditions to $1,000 a month. My minimum. My concern is with the minimum, Judge, because I do think it's a vague condition. And
at minimum, 1,000 is not vague. He makes 1,000. That's what it needs to be.
Okay. What I'm
he will not get revoked if it's 1,000. But it's also what is reasonable. And reasonable for each person is different. What their capabilities and the efforts that are put into acquiring the income are all part of the equation that this court is going to review and test each time we are here. The 1,000-year plan is not acceptable.
I understand.
Okay.
But as long as we're clear, he's making the $1,000 a month payment. He will not be revoked.
In 3 or 4 months, we will review it.
Does that change your
No,
answer?
I'm sorry, 3 or 4 weeks, we're going to do this monthly. We're going to do this monthly, we're going to review it. And if this court is not impressed with the efforts that are being made, because these are promises that have been made for years that have not been forthcoming.
Which is why I'm trying to get him.
He's an electrician, a skilled electrician. I know what they're making per hour.
He's also
more than I'm making per hour.
We expect that we could show, we don't need the, but we expect to show that he is working, he's had jobs, not making a lot of money. He's been kind of embroiled in this area with this offense. It's well known. People even are still reporting on it.
Right now, his order is a minimum of 1,000. And that minimum will be reviewed each time for a change. It's not, it may change or it may result in revocation. And it's the court's determination. It's still based upon not his standards, but the reasonableness standards. Reasonableness with his circumstances.
I need 1 moment to discuss this.
Yes, sir. Go ahead.
Client, please.
Yes, sir.
With the $1,000 being ordered today a month, subject to change in the future, Mr. Walker will still agree to sign these properties over for that valuation.
That's got to be done immediately.
Yes.
Yeah.
We haven't
Today, in the next few minutes.
We haven't seen the deed yet, but I'm sure
I
that's
understand.
standard.
Yes,
I don't even
sir.
know what a quit claim deed looks like. I've heard of it. In any event, the other thing we discussed in order to help Mr. Walker make his payments is taking the GPS device off. So that would also be amended. Okay. So we currently have a bond.
But Mr. Walker is required to stay in Jefferson County unless he gets approval from the probation office so that he can leave for purposes of work to pay this restitution.
All right. So just for the record, our current bond conditions are essentially amended today for the $1,000 a month minimum payment, which could change, and also removing the GPS and allowing travel within Jefferson County. And he has to get permission for any other travel.
Yes.
Okay. Okay.
And again, the decisions this court's going to make in the next hearing, the calculations are going to be what is being done reasonably to get income to pay this restitution back. And that's going to be the test. Are you making a reasonable effort and reasonably best efforts to get income to pay the 100,000 plus victims back?
I understand. I just, we're not objecting today to the $1,000 number being ordered. My understanding is today that's the order.
Yes. And it will be subject to change subject to the next hearing.
Okay. My issue, we would have an objection to any reasonableness standard, which I don't think is the standard from today. I think the standard today is $1,000 a month, subject to change. We would object to this, what we consider vague.
Here's why you can't. Here's why that court's not going to get caught up into this. If Mr. Walker doesn't do a thing, well, you just got him. Well, he doesn't have to really do anything now. He's not subject to any efforts to try to produce an income.
Other than
that's why that won't be the test. A reasonableness. is going to have to impress this court, and I will articulate my determinations, and it can rise and fall on what a reviewing court deems whether this court is acting in a fair way on his efforts that are being made. But without that test, he can do nothing and just say, I'm back here. I'm going to keep this 1,000 plan and this 1,000 year plan, and that is not reasonable. And much of the law is based upon a determination of reasonableness because every set of circumstances is unique. But paying restitution over 1,000 years is a late night joke. And we're not going to be part of that. We're going to act responsibly, and that's not responsible under certainly based upon his own statements that he made of his capabilities, qualifications, his income capabilities, and also in light of I spent more in the commissary than I have paying restitution.
If I may, Judge.
That's a painful, I keep throwing that out there because the people find that nauseating.
Just so the record is clear, we're not going to object to the $1,000 minimum, but we will object to the reasonableness standard, which I think is overruled.
Yes, sir.
Okay, that's
and like I said, because without a test, he doesn't have to do anything.
Gotcha. And the objection is on.
And it's only, this order is only until this next hearing. And then the court will make its determination whether the defendant has satisfied this court that he is doing reasonably, taking all reasonable efforts to get the victims paid back what they can.
Got it.
Yeah, okay. Yes, sir. What else? Anything else, John?
Okay. No, I was just checking my client. No,
State.
Noting the objection being overruled, I think that's decision.
Anything to add from the state?
No, Your Honor.
No.
No, Your Honor.
Okay. Then I'm going to get these deeds here from my attorney, have him bring those in, and the defendant shall sign those quitclaim deeds, turning this $164,706 worth of value in these 3 properties that he owns to the Beaumont Independent School District. We'll do that immediately. Okay. Anything else?
That's it, Judge.
I think this location is the others, 131 and Super 8 Motel. This was at 10:20 at night on January 9th, last year, 2025, at the beginning of this year. Operating while intoxicated, as I told you, is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Prosecutor has also agreed to reduce yours to impaired driving. And same as the others, it will allow you to keep a restricted driver's license to drive back and forth to work, treatment, court, other limited purposes. But it is punishable by up to 93 days in jail and a fine of up to $300, 4 points on your license. Do you understand?
Yes, Your Honor.
And I've also got your advice of rights. Anybody threaten you to get you to plead to this?
No.
Where were you going?
Well, I just got a new car that took diesel and I wanted to fill up my gas tank and get my car washed because I had to get up and leave at like 5:30 in the morning for work meeting an entire day.
Well, you got a Mercedes, so you live in Kalamazoo or Vicksburg. How'd you happen to be in Three Rivers?
Well, I was looking for a gas station that had diesel because the one in Vicksburg does not. And got lost. Was happy to see lights and a road and then got pulled over.
All right, what was the blood alcohol?
It was forensic state police crime level was 0.179.
Well, that's pretty drunk to be driving around at night. I'm glad you didn't get hurt or worse. Good morning. Good morning, Mr. Zambrano. All right. John, are you available on that December 1st date?
I believe I am. I'll verify it really quickly when I get back to my office. I don't have staff there today, but.
All right, we'll set it for December 1st at 11. That's open.
So she was hoping she could do a sentencing on a Friday. That's her work schedule, but if we have to do it on a Monday, that's fine.
Well, we don't. We have the other problem with Ms. Strong. We set up time with our screenings for Mondays.
That's fine.
And
we'll make it.
We'll have to just work around it.
Okay.
But Fridays are full of landlord-tenant cases. And so it's hard to do a criminal case in the middle of a civil day. It's not impossible, but where do you work, ma'am?
Drake Dental.
Oh, yeah, you told me that. There's red flags in here that you were that intoxicated. And again, as I still told the others, that you lose your judgment. That's if you had a couple of beers, you think, I should do that. You were more than 2 times the legal limit. And
she's doing services. She's on a domestic probation in Kalamazoo County, and she's doing services through the YWCA right now.
Very good. We'll want to know about that. The important thing is this will allow you to keep your driver's license to get back and forth to work at least.
My mom.
All right, I'll send you out Mr. Bush.
I know it's December. I didn't catch the time.
11 a.m. You don't need to go with Mr. Bush. The bailiff will take you out to the court office. Who's Amber Moyer? Oh, Amber Moyer. Is Amber Moyer here? All right, I haven't forgotten you. You stay right where you are. Do you have your insurance and other information with you today?
I don't have proof of insurance, but I got the where I sold the car.
All right, well, let me, good morning.
I got the license too.
Ms. Wyatt, oh, very good. So you have your license and have insurance. Got rid of the car.
Insurance, but
Got rid of the car. All right. All right.
So should be good, right? Thank you, John. Have a nice weekend.
All right, very good, Ms. Moyer. You have a seat for a minute. I've got a walk-in that we're gonna take while we got a break here. Teresa Lentz, would you come up to the podium, please? Right there, right where the microphone is, right there. Somebody's been there yet this morning. Good morning to you. Are you Teresa Lynn Lentz?
Yeah.
All right, this isn't on my calendar because you came in to check on something and they found this part. Paul, are you ready to go? Are you ready to go?
Yes.
All right, we'll take care of this matter and then we'll address yours.
Okay.
Ms. Lentz, let me find this because you're not in my queue.
I don't even know what it's about.
Well, I'll tell you in a minute. Vivian, let me take care of this case and then we'll address your plea and I'll get you on your way. Well, the allegation is that on September 19th of this year, he stole an electric bicycle that belonged to Jason Bowser, worth more than $200, but less than $1,000. That's a misdemeanor, punishable by up to a year in jail and a fine of up to $1,000. The larceny was reported to me. The defendant drove his e-bike to Myers and had it in the parking lot. Two suspects that stole it left in a Ford Explorer with the trunk open. When he confronted the suspects, they immediately took off. My camera footage showed a female subject pushing a cart with groceries through the parking lot. Male subject puts it over and puts it in the car. They use your transaction from in the store and the footage to identify you. The other dude is alleged to be David somebody. All right. If someone stole my e-bike, I'd be really mad about it.
Yeah.
How do you plead to this charge?
I want to plead not guilty.
All right.
Because
I'm going to appoint a lawyer for you on this.
I did not know that.
All right, that's fine. I don't think the prosecutor is going to believe that, but we'll see. Somebody randomly puts a e-bike in your trunk. There's actually a warrant for your arrest. She needs to get printed. Appoint an attorney. Set attorney pretrial for 12/5. Gonna be busy that day too at 8:30. Bond $250, cash or surety. Barred from Myers. Needs printed. So I'm not gonna be taken to jail. I'll have the officer take your prints.
Thank you.
And we'll get an attorney for you, set up for further pretrial. Who's David? What's David's last name?
Turtles.
Tuttles?
Turtles.
Oh, Dave Traddles. All right, well, we'll see where this goes, but for now, we'll get a lawyer to help you with this. The officer will fingerprint you, he'll sign a bond form. I want you to call your lawyer, make an appointment to discuss it with him. And I will see you on December 5th.
I don't know who that is.
Well, we're gonna give it to you. We'll give you the information. All right, let me duck out to the prosecutor's office for just, or the back here for just a minute. See if we can take care of a couple of these.
Your Honor,
Yes,
I apologize. Ms. Moore is not checked in yet.
you can go.
Thank you.
That's just a,
Sorry.
it's just a further lack of cooperation from the defendant. You were here yesterday, she didn't show up. Said of her this morning, she didn't show up. She's got 20 unpaid tickets. She doesn't pay, she doesn't show up. And then she's gonna get a bench warrant for her arrest. There will be a 48-hour hold on it.
Thank you. I did, I wanted to indicate for the record, she did email me at 8:30 and said she was on her way, but she's still not here. And I believe she's in the Sturgis area. So I'm not sure if she's, sounds like the vehicle is not the most reliable of vehicles. So I don't know if that's creating conflict, but.
Well, it's creating conflict for you, so.
Yeah.
All right.
Thank you.
Thank you. Give me one moment. Paul, I don't have I think I have the sheet on your guy. Do you have it?
No, I don't have it. I could walk back.
Oh, let's see. Maybe it's in here. I don't know it.
I didn't get it before, so.
Of everything. First, I think that one today. I'll put the other stuff on a payment plan. For the no ops in possession, which is also a good deal. It carries no points. That one is the same thing, $75 fine, $75 crime victims' rights fee, $50 state minimum fee. You owe a total of $205, and I want you to pay the $5 today. We're gonna put that other 200 on the payment plan. That's one of two. Thank you. All right, that takes care of everything that was pending, but we got a new case we need to address. So that's very good. Talk about the new case. This is file 252256. I better get a register of actions here. You're charged with purchasing a pistol without a permit or possessing one. To obtain a pistol in violation of the statute by possessing and having in his control a pistol without first having obtained a license to possess or control the pistol. It's a misdemeanor punishable by up to 90 days in jail and $100 fine, and it requires forfeiture of the pistol. That came out yesterday. I'm not going to lodge you on this. You show up for your court hearings. Do you wish to plead not guilty to that charge?
I wasn't aware that this charge was being brought against me at all.
Yeah, it just came up. So I think now, I know you don't like me to appoint a lawyer for you, but I think you could use some help. So at this point, regardless, you wish to plead not guilty, correct?
Well, that whole case there, I think there's going to be a lot more to that.
It looks like it from the affidavit of probable cause.
Yes, sir.
It looked like a big rigmarole. There was a search warrant. There were other complaints. I can't sort it all out.
I feel as though that my constitutional rights were violated.
All right. Well, I would like to appoint a lawyer for you. Would you allow me to do that?
Sure.
All right. Very good. I'm going to set an attorney pretrial for December 5th, 2025 at 8:30. You need to get printed. I'm going to set a $250 PR bond. You showed up, you didn't even know there was a warrant. I'm not going to have you taken into custody. I'm going to set a PR bond. You let me appoint a lawyer, and you may have some legitimate defenses that lawyer could explore. I want you to give your correct address. One thing says you live in South Haven, one thing says you live in Mishawaka. I thought you were down by White Pigeon.
Your Honor, where I live actually does not have an address. It's a plat on a lake.
I remember that parcel of property, but we need to know where to send mail to you. All right, I'm going to send you out to the counter. They're going to do several things. They're going to appoint a lawyer for you and give you a notice for that December 5th pretrial. They're going to set up a payment plan on these traffic cases that have been resolved today. And I want you to give them a mailing address and phone number so you know how to get a hold of it if there's an issue or something. So the traffic stuff's all done. You ended up with no points, some fines, and I gave you a payment plan. And that's probably as good as it was going to get. Then this case, I didn't have you taken into custody. I gave you a PR bond, appointed a lawyer, set it for hearing. So you also need to get fingerprinted. So there's a lot left to do before you go, but let me send you out with a court officer.
Your Honor.
Yes, sir.
What about the truck?
The what? I don't have an answer to that.
Your Honor, I recommend he contact
The
the,
sheriff's department.
well, I don't,
Where was it?
think it was
Where were you when you were pulled over?
I was on Wallowell Road and
Sturgis?
it's in between Sturgis.
Yes,
and
it's, my guess is your vehicle's in Sturgis, but I don't know that. As Miss Camfield said, sometimes they'll just do a no preference record and whoever shows up does it. But I don't have an answer, and neither as a prosecutor from the ticket. So I would start with the sheriff's department, see them tell you where the vehicle is. You're not going to like it when they tell you how much it costs. All right, you can go with a court officer. That's why I gave you a $5 fine. I figure I had enough problems. So I'm good to go. You're good to go.
Actually, Mr. Zambano, that citation was written by Michigan State Police.
Oh,
so if you
MSP?
contact the Post, they might know who it is.
I have. That's hard to do. Ask the ladies at the counter to give you the number of the state police post, because there's nobody in White Pigeon. They're all in Marshall someplace. So we'll get a number for you to contact them.
Thank you.
All right, thank you. All right, let's clear some people out of here. Let's talk to my friend Tiffany Wyrick. Miss Wyrick, would you come up here?
Do I sit down or stand?
Sure. This is file 251528, Tiffany Z. Wyrick. Haven't seen you in a while. You're living in Kalamazoo.
Nice to see you.
Thank you. You got a driving suspended and unregistered vehicle, and Mr. Knopfinger is your lawyer. You got an unpaid zoning ticket from way back in 2021. You owe $120. But Luke, you're asking me to set a final pretrial in this case?
Yes, Judge, there are some things going on behind the scenes, work out the license issue, and that's something that can't be handled here today.
All right, Tiffany, you're working on getting your license back?
Yes, I am.
That would be a good thing. All right, we'll reset this for a Thursday. It'll either be in December or possibly even in January. I want you to stop out at the counter and find out about that old unpaid fine.
Yeah, I asked them about that last time I was here. I said, do I have any money I owe? And they found it. So.
All right. All right, well, I'll see you on a Thursday afternoon at 2
I want
o'clock.
to tell you something.
Yes.
There's a Wyrick on your force. My son is a cop.
Is he really?
Yeah.
The fact that you have a son that old makes me feel really old,
Yeah.
because when you and I first met, you were about 16.
Yes.
Which department's he on?
He's in Sturgis. He lives in Sturgis, but he wants to be a state police. And he graduated from Glen Oaks with the criminal law, criminal justice, and he's been approved for Customs Border Patrol.
Oh, boy.
He's trying to go down to Texas to do Border Patrol, but I want you guys to give him a job around here.
Okay. All right.
Yep.
Oh, you must be very proud.
I am.
All right, I'll see
I know
you.
my mom would be so happy.
Yes, she would be.
Thank you.
All right, thanks.
Thank you so much.
All right, Mr. Michelson. Trying to keep you awake back there, but you wore a tie in here today, so it tells me you're taking this seriously. And this is just, and depending on how you say it, Michelson, I say Michelson.
Yeah, you pronounce it right.
You got a charge, a not very serious one, of no valid operator's license. Same thing, is he working on his license?
Yeah, Judge, I'm gonna get a certified driving history and see what we can do.
You were in Burr Oak, St. Joe Road. Is that where you are? Are you on parole or probation or anything still? You're off everything?
I'm on bond right now.
Okay. But this is a minor traffic matter, and we'll set a final pretrial. The address is correct?
Yes, sir.
I thought you owed me some money. I think I lost one of the pages of my thing, but I don't see it here. So let me make sure you don't. You're in bond in the circuit court?
Yeah, I think so.
All right. I spell it wrong. Yeah, you got a bunch of old unpaid zoning fines. But other than that, No. You got a bunch of stuff. Yeah, you're bound over to circuit on that other case. All right. I want you to stop out the counter about the unpaid fines. What?
One on top. ZPT is definitely the wrong birth date.
This one?
This is 1980.
So that's not him.
Right.
Well, that's what this all says, 9/24/80.
I don't think you were born in 1980, were you?
Yeah, I was.
Were you? Okay. This wasn't a good one.
Yeah, there's some old stuff on it.
Okay, sorry about that.
All right, would you take that up,
Absolutely.
Connor? Why don't you stop out there? Luke's gonna help see about your license and you're good to go. All right, good morning, Mr. Stanek. Stanku, Daniel Luce. We're gonna resolve that case. I haven't seen Mr. Gibson. He's got a bunch of cases. Yes. You have another one? What are we doing with this? We're gonna take a plea?
No, we're gonna.
No, in yours, Luke.
Yes.
All right, in this one, let's call the case. Daniel Scott Luce, file number 252089. Oh, the offer was to trespass, which looks like a pretty good offer. It's a very minor misdemeanor with a fine. The charge is illegal entry without owner's permission. Says here we're going to set a final pretrial.
He's got an outstanding case in circuit court that has very serious charges attached to it. So our intention is to try and find a global resolution, combine everything together. So we need a little bit of time to do that. So what we want to do is set it for a final pretrial to see if we can put everything together.
All right, there's some logic in that, to be sure. Scott Luce, not Daniel. And that case is 252088FY. That's the district court number. Yes, there's a lot going on with that case. I had to open the search. Is it set for a status conference or anything up there?
I think so.
All right, Mr. Luce, are you still at the Washington Street address at the trailer park in Constantine?
It's 1/7.
Well, I don't want you to give it to me here on the record, so everybody. But if you'll get that, I'll send you out to the counter to give the clerk your current address.
Your Honor, I see a status conference on December 19th.
All right, I would have to go to circuit court to look at that, so thank you.
You're welcome. And jury trial, January 27th of next year.
All right, very good. So that doesn't mean it's actually going to be a jury trial in January, but that's the target date. All right. You're good to go, sir.
Thank you.
I want you to stop out the counter and give them your contact information. All right, Mr. Stanku, that's the only one you had?
That's it, yeah.
All right, it's a long drive for that, but thank you for being here. Would you have them take that out there? All right, Luke, you got a plea for me?
Yes, Judge.
Michael Wisniewski.
Wisniewski.
Thank you.
As I learned, Judge.
All right, well, we are all learning. What?
She's in the-
Yes, that's there.
Let me approach Judge.
Mr. George, do you have any knowledge about Miss Conway?
I haven't heard anything, and Mr. Gibson has that.
I know he does, but some of it's ordinance.
I think we have one ordinance file and we just allowed the prosecutors to dispose of that.
All right, well, she's sitting back there in lockup. Paul's always hard to pin down here. We'll see if we can get a hold of him. Good morning, sir.
Morning.
Are you Michael Wisniewski?
Yeah,
Or say it for me.
Wisniewski.
Wisniewski, all right, that's important. I try to get it right, but. Take a look here. You got a ticket on September 31st for operating while intoxicated and improper lane use. This is an interesting plea offer. So they're going to dismiss the operating while intoxicated, and you're going to plead to reckless driving, and they're going to dismiss the ticket. Is that correct?
Yeah, Judge, and there are some other terms that I don't think are included in the sheet too. We stipulate to payment of the reimbursement of $120 that was requested. And then the doing a victim impact panel.
All right, well, let's take a look at this. Operating while intoxicated is a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. You live in Indiana?
No, Michigan.
All right, did you have an Indiana license at one time?
I still have an Indiana license.
All right. Reckless driving does not include alcohol. It is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It carries a 30-day suspension, I believe. This is alleged at 3:30 in the morning here in Centerville, Main Street, Clark Street, right here near the courthouse. You were doing something. Are you going to plead to reckless driving?
Yes.
A ticket of improper lane use is $120, so that's better than nothing. All right, anybody threaten you to get you to plead to this?
No.
Promise you anything?
No, Your Honor.
What were you doing at 3:30 in the morning right here in front of the courthouse?
I live at the trailer park.
Okay.
And I missed my turn. And I used the turn lane to turn, but I rode through it the whole way.
So, did you crash into anything or something?
No.
Did you go over the curb or anything?
Nope.
Where were you coming from?
I honestly don't remember. Like the exact name.
Was there a blood alcohol here?
Yeah.
What was that?
Your Honor, it was a 0.08, 0.09. And he was in the turn lane and then instead of turning, continued straight through the intersection.
All right, well, the alcohol in there is enough to get me over the hump. Well, this is a giant break. This isn't going to show as an alcohol case, but it is going to restrict your license or suspend it for a bit. Ms. Campfield, do you have any objection to me doing the sentence right now?
I do not, Your Honor.
All right, well, what do you do, sir?
Me?
Yeah,
Nothing right now.
what kind of work have you done?
What kind of work?
Yeah.
I previously worked at a pallet company, building pallets. That was before I moved. But since I moved, I've been trying to find a job.
Mr. Dawson, anything else you want me to know?
No, Judge, he was arrested and he was in jail. He's getting out maybe 6, 7, 8 a.m. Would ask the court to consider that. I would ask for fines and costs. Judge.
They spent a night in jail.
I think the statutory presumption would apply, Judge.
1 day credit, 1 day. What is driving wasn't actually that reckless, but with the alcohol factor, you were over the legal limit. And there's some tolerance acceptance for the measurement. So it's right close at the borderline. What were you drinking?
I had beer and Mike's.
Which department was this?
Let me just double check. Constantine Police
All
Department.
right.
Officer Leslie.
I think it was the joint department. Judge.
Correct.
Yeah.
Centerville.
$100 fine, $75 crime victims' rights fee, $50 state minimum fee, $120 attorney fee, and the VIP, $32. $100 plus 125 plus 150 plus 120 police reimbursement plus $32, 527. Do you need a payment plan for that?
Yes, Your Honor.
And we're going to refer you for the victim impact panel. It is going to carry a suspension, but it isn't going to show as a drinking driving offense, and that's a blessing. All right, I want you to go out to the counter. They're going to set you up on a payment plan, and they're going to get information scheduling you for the victim impact panel.
Okay, now.
All right, good luck, sir.
Thank you, Judge.
All right, Troy Heemstra.
Morning, John.
Good morning, sir. Are you Troy Heemstra?
James Sandra. It's hyphenated.
Troy, you go by James?
That's why I prefer to go by.
All right, fine. You're here with your lawyer, Mr. Tim George. You've got 2 counts of domestic assault. Those are misdemeanors punishable by up to 93 days in jail, fine of up to $500. Prosecutors agreed to dismiss those charges for a plea to disturbing the peace. It's a pretty generous offer. Disturbing the peace is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $500. Are you going to plead to that charge?
Yes.
Anybody threaten you to get you to plead to that?
I'm sorry.
Anybody threaten you to try to get you to plead to that charge?
No.
Promise you anything other than those other charges would be dismissed?
No.
All right, you've heard me go through the advice rights a couple times here in the courtroom, but you've also signed a waiver. You understand you're giving those rights up by entering this plea?
Yes, Your Honor.
All right, let me find this. All right, you were living on Fisher Street, which I think is Parkville?
Moore Park.
Oh, Moore Park, all right. And you were living with Casey Fenwick?
Yes, sir.
Did you and she get into an argument that day?
No.
Tell me what happened.
It's a kind of a private situation, but basically we were doing something in the garage and she accidentally made a phone call and her friend I guess from whatever she heard decided to
send a welfare out to check on her.
And then they showed up and I mean, you know, the past that I have was being at that house.
Yes.
And I didn't have any clothes on, so I kind of ducked out. And she, well, I understand. I mean, I wasn't there, but she kept trying to tell them that nothing was happening, you know, and they didn't take that for a.
Well, she had a bloody lip. And
yeah, I think that
she said
I grabbed her from behind, like in the beginning, and I think that pressed her lip against her lip. But as far as I know, the police or the prosecutor sent the police back out to retake her statement.
And Your Honor, the report does indicate that when officers did arrive on scene, they could hear some type of male and female voice in the garage that was loud enough to investigate further. So I think the facts are sufficient for disturbing the peace plea.
How long were you in jail? 2 days?
I believe so.
You got arrested on the 16th and they gave you a cash or surety bond.
When they arrested me, they asked if I wanted them to, if I wanted my phone to go with me.
Mm-hmm.
But when they put me in the car, my phone disappeared. So
I would like. to
Well,
know
I'd
how you-
stop out at the sheriff's department.
Okay,
I don't know anything about it, but I would start there. 1 day in jail credit, 1 day. Posted a surety bond. There's a $75 fine, $75 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, which is $350. I think I lost the second page of my cheat sheet somewhere earlier in the morning. And let's take a look. Is this the house where they had all the stolen stuff?
but when,
The
like
house
while
on-
I was in jail or
Yeah,
while I
well,
was
like a
gone?
couple of years ago, the stolen motorcycle and all that other stuff. Was that in this place?
If it was while I was gone, maybe. I know there was a bunch of homeless people a few houses down.
Yeah.
And I know they had a bunch of.
Whose house
stuff.
is this?
Steve Fenwick owns it.
Okay,
And then we're buying it from him,
all right. Well,
which a lot of the people around there, are some shady characters and they don't really like me there because then things are on the up and up. I'm trying to change. And
well, I'm not sure what you're doing naked in the garage, but I guess I speculate. I'll just leave it at that. But can you pay $350 within a time period, or you need a payment
How
plan?
much?
$350.
I can come close to paying it.
Well, I'll give you some time to pay. I'll give you a January 15th.
Okay, I'm gonna pay at least a couple hundred on it.
That'd be great.
Cause I want to get this over with.
I don't blame you a bit.
What do I do? Like people keep calling and sending the police to my house in the middle of the night and day when I'm there, when I'm not there. Like,
I don't know. That's something like a swatting thing. They're just sending people to screw with you, or they're concerned about something.
the guy that they dropped her off at is Scott Bell.
Mhm.
He's like a pedophile and all that, which, and he's just not good. He's not productive to a positive lifestyle for me. So
He doesn't live there?
no, he lives down the street. That's actually where the police ended up taking her when they came, which then when she came back home in the middle of the night, like he wouldn't leave. Like he didn't want to leave.
Whose house is it?
It's her house. Well, hers and her dad's. Our house. He has a house down the street.
Yeah, but I guess.
And kind of won't leave her alone. On the same day that I got arrested, she had blocked him, and because there was a whole thing of him trying to start stuff and whatever.
He sounds like a good guy to stay away from.
Yeah, so that's what I'm trying to do, which she blocked him, told him to quit coming to the house. Well, apparently at 4 a.m, somebody called for a welfare check.
How recently was this?
This was when I got arrested.
Okay.
And somebody called, we were both in bed sleeping. She had no missed calls, but somebody called for a welfare check, and it came like 4 times since then, from what I understand.
I don't know. This is gonna lift the no contact provision. I would go out to the jail when you leave here, take this with them, see if they'll give you your phone back.
Okay.
All right, you go out to the counter.
Thank
Oh,
you,
wait a
Your
minute.
Honor.
I didn't give an envelope.
Yeah, you did.
All right, you're good to go. All right, I think everything else is Mr. Gibson. We've got dozens of people here waiting. We got people in the lockup. I'm gonna stop the record for a minute. Thank you all for your patience. Looks like we're gonna go into the lunch hour again. Mr. George?
Yes, sir.
What happened to Mr. Kuhn?
That's
Ashton
not my
Kuhn.
case, Your Honor. It was a Three Rivers case, so we had to give that over to Mr. Gibson.
All right. I don't see him. I know he was here.
He's here.
I was told he was here. All right, everyone. Thank you. I'm gonna take a recess. There's cookies in there. Do you understand?
Yeah.
Where are you gonna stay? And I let you out,
I can go to Three Rivers, I can go to my Aunt Brenda's.
because you're about to get out. You're gonna be standing on the front steps of the
Yeah, no,
jail.
I got my debit card too.
Will someone come pick you up?
Yeah, I can call.
All right. You can't drive, you understand?
Yeah.
All right, till you get this straightened out. This one, I'm gonna order 27 days credit, 27 days. 0 fines and costs. I did these all in the same circumstance. This one carries a minimum $200 fine, $75 crime victims' rights fee, and a $50 state minimum fee. I'm gonna waive the attorney fee. You owe $325 as part of your payment plan. $10 a month for all this, I'll be 90 by the time you get it paid off, but maybe it will happen. And on the driving suspended for the same day, I'm gonna order 0 fine and cost, but 27 days credit, 27 days. All right, Miss Conley, how about if you don't come see me for a while? You're just barely hanging on. You're struggling with your mental health issues. You've
Yeah,
got no money.
unfortunately, the last time I was here, you didn't know it, but that signature you signed wasn't even a cop that arrested me or a detective. It was illegal. So you didn't know that, so I did my math, I studied on it recently. So I got arrested illegally and I didn't have a warrant
On the
either.
old case?
I didn't have a warrant and you guys arrested me illegally on private property.
I think you're mistaken.
No, I'm not.
Let's- Well,
I
that-
pled, remember when I pled to it? I did that, so another reason why I did that misdemeanor is because I wanted to know that guy's name so I could make sure and do my research on it, because that was illegal. That was 8 months of my life away from my 3-year-old, who's now almost 3. And then I also was really fairly pregnant and large in this jail, and the officers knew that too, and I was delivering a baby in your jail and they did nothing to stop anything. It just pretty much just died. It was like 8 months on. They didn't give a shit.
I don't know, Elizabeth, but I'm trying to get you out of jail today.
I
so-
know, I'm just saying, I'm just letting you know, it was really incorrect. You don't know who's a cop and who's not, so you didn't know anything about it, so I'm not mad.
All right, well, you can go with officer.
Yeah.
Why don't you bring the other lady? All right, good luck to you, Elizabeth.
You said it, all right.
Yes. Now, that person is,
Helen Olowski.
some cases here. We just couldn't wait anymore, Paul. I had to just get started. $18 days credit. Good morning. Are you Helen
Yes, I am.
Evelyn Olowski?
Yes, I am.
Let's talk about your case.
I don't know if that's it.
Ms. Orlowski, the allegation is that on July 23rd, you assaulted Scott Lego on
Yes.
Burke Road in White Pigeon.
Yes,
That's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500.
okay,
Apparently the offer Ms. Stoll is a domestic violence with deferral.
That's right.
The way that works, Ms. Orlowski, you would enter a plea to domestic assault and I would put you on a probation, and if you successfully complete the probation, the charge would be made non-public. You'd have no public record of conviction.
okay.
Do you understand?
Yes, I do.
All right, now you weren't in here, so I got to throw this again. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, I do.
If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, I do.
Anybody promise you anything to get you to plead to this?
No,
Or threaten you?
no.
All right, were you living with Mr. Lego at Burke Road?
Yes, I am.
And did you get in an argument with him?
Yes, I did.
Did you throw some scissors at him?
Yes, I did.
Poked him in the leg?
Yes, I did.
And he was drunk?
Yeah, maybe. I didn't think I was.
No, him.
Oh, no, I was.
Oh, you were, but he wasn't? Okay, you were drunk or you weren't drunk?
I were on a
All
little
right.
bit, not a lot.
All right. All right, so they issued this warrant on September 15th. The incident occurred in July. The warrant got issued in September, and you got picked up 18 days ago. Do you both still live at Burke Road?
Yes,
Do you have any criminal record? I didn't see anything. Is this the first time you've ever
No,
been arrested?
no.
Who owns the house?
Scott does.
Where are you gonna go if I let you out of jail?
I don't have a place to go. I take care of him. I make sure his bills is paid.
Do you have any source of income?
I have SSI Social Security.
Okay,
That's all I do. I have. It's not that much.
so he needs your help.
Yes, yeah.
All right, well, I don't want to do an immediate sentence. I need some input. I don't want to just let her out of jail and then she's back in the house, but I don't know what he's got. Do you have any victim input?
I was going to AA Alcoholics Anonymous meetings, and I've been going to meetings here. at the
Well, I'm
jail.
gonna put you on probation, so Mr. Gibson, are you available next Thursday at 2:00 or 2:30?
Let's see. But I think I left my briefcase out in the hall.
Maybe somebody walked off with it. Abigail, that's another short notice, but she's in custody. I suspect he probably wants her out. But he did get stabbed in the leg.
Yeah, our office hasn't heard back from the victim.
All right.
What time on Thursday of next week?
Okay, what's the issue in this case?
So there are two outstanding issues in this case. We're asking for the defendant to trim his weeds that are along his lot line and also remove a damaged vehicle from his driveway.
So those are the two issues?
Those are the two issues.
Well, we understood there to be more issues,
He's
but
corrected everything else.
Okay, so there were more. He's corrected them. These are the only two that are left.
Yes.
all right. The trimming weeds, I suspect can easily be resolved if there really are some trimming weeds that need to be done. The removed vehicle is not part of any pleadings. As far as I can, it's not, it is operable. He drove it yesterday to my office, has a license. He has two vehicles. So we can present evidence.
There. Okay. So from the landlord's perspective, what was wrong with the vehicle?
The vehicle at one point did not have registration tag. It does have registration.
What was the last thing you said? I'm sorry.
It does have registration.
So it's got registration tags, it's insured, it's drivable.
Yes.
So that seems to me to be an issue that is also now being corrected. Maybe.
So they wanted a conditional dismissal. I got it. He's just wanted to demonstrate that his cars are registered and very much valid.
These are the two issues. I was going to let Brother Counsel look at them before I had them passed.
So these are the two issues, was the car and the weeds.
Yeah.
Okay.
Let me confirm. We talk about these.
Yes, that's it. Got a covered car in the picture.
Pardon?
We have a covered car in the picture. We don't have a problem with that one.
But that wasn't, the covered one wasn't the one you were
No,
talking
it's
about.
not.
Gotcha.
It's the damaged vehicle.
Vehicle.
It's the. It's not going to resist now. It's dead.
I guess this weed line is something that has been flowers.
Yes, D.
Okay. So I'm not sure what you're saying.
L-Y, L-Y, L-I-L-Y, D.
Lily?
Lily.
So he's got to weed it then, Your Honor, because all we see are weeds, no lilies. And of course, this isn't the time of year for lilies, but
One man's weed is another man's flower. No, but.
fortunately, in our meadows, you're not allowed to have,
No, I didn't plant. Sorry.
No, it's okay. You didn't plant it?
I didn't.
These have always been there.
Comes up every year.
Right.
Oh, so can I see him? It's some type of perennial that just comes back or no?
Yes.
Okay, the management, she's shaking her head no,
Oh,
and I don't.
I don't know. You want to speak, Dave?
Yes.
Are you talking the grass stuff?
Yes. This
Oh, those aren't lilies.
trend.
No, they're not, at least don't appear to be lilies at this.
No, well, yeah. I mean, I'm no expert, but I bet you these are lilies. I'm just, but right, this comes up every year because it's basically grass weed. So what's your client's position on this? Other than on the back of a tractor mowing it down? No, I'm sorry. Go ahead.
Flower, I did not plant. And I can take them off every fall.
Every fall? Okay.
Yes, it's a.
All right, so are you willing to take them down now?
It's just I'm taking care of. I understand that's not mine. Because the land is not my property. And I can take care of.
Well, who?
It is his lot line, Your Honor.
Okay, that's what I was gonna ask. I mean, it's gotta be your lot line only if the covered vehicle is properly parked, your lot line has to extend over a certain number of feet. So I would be shocked if this were the neighbor's lot.
All right, so you're willing to take it down? All those weeds, your lilies, you'll cut all that.
That's right. The flowers comes up every year and it dies every before winter. And
So let me ask this, and maybe the management knows, because they probably see it all the time, because with this picture, are there flowers that come up before the overgrowth comes up, or?
If there is, they don't show.
Gotcha.
A closer.
Right, but if what I'm hearing from him correctly is that somewhere in the midst of this, there are flowers.
Correct.
And that those kind of just grow there. And then in the fall, as it goes toward fall, this is what it begins to look like.
Is that correct? Flowers grow in that area, and in the fall, this is what it looks like. The weeds come up, flowers don't. Any longer, correct?
Okay. So that's what I'm hearing. What do you?
So it's like this all year long. The flowers, there may be a couple flowers that may pop out, but it's weeds that need to be cut. And if he wants to plant flowers.
So if he wanted a flower bed there, he could have a flower bed, but I think.
That you have to weed.
Yeah, these are weeds. So what I don't want to get into, and we may be getting into it without it being said out loud, is a problem that they had in Ann Arbor and part of Pittsfield where the natural flowers or native flowers that a lot of people would call weeds became flowers for people's lawn extensions. I think the community rules, at least the last time I looked at them, kind of prohibit that notion from occurring.
Well,
That's what I was gonna say, Your Honor. Unfortunately, because he does live in the private community, the manufactured home community does have rules regarding even the type of flower bed you could have. If you were gonna have a flower bed or a raised garden, you still have to get permission from the park. Approval.
Okay.
I guess I'll just say this, is as far as I know, this line of weeds, flowers has been there a long time. I don't think he's been brought, go ahead. You have something better to say than I do?
Yes. Do you have a picture?
Oh, that picture?
No, another one.
Yeah.
Yes.
Awesome.
Yes. In this picture, it is black and white. So it's a little bit harder to distinguish which one is weed, which one is flower, which one is grass lawn. The last time, the big tree is removed here from here. And after tree removal is done by Aba Meadows. And then Aba Meadows told me they will put grass seed, but they didn't. This is the remaining ground is just bare ground.
Got it.
Because that is just natural ground. Yeah, weeds comes up. I tried to cut by lawnmower, but the ground is not flat, and the weeds tend to grow up faster than lawn. So I thought that weed means those weeds from those area because it's more visible than others.
But if they had put grass there, you'd have to cut the grass.
Of course.
Right? Okay. So, I mean, this is actually really simple. That's got to be taken down. It's got to be mowed over.
Yes, I believe I'm taking care of lawn cutting very well.
Okay. And so that part has to be put in there. So that's got to be taken down.
Right. The last time, that is 5 years ago, Aba Meadows complained about lawn cutting just $50 and filed to the court. But since then, I always cut the lawn, the appropriate timing, and I believe I never failed.
So, and Mr. Stringer, you had mentioned they wanted a conditional order dismissal regarding it, or what did they?
Well, that's what they're asking for, but I mean, he's agreeing to cut the grass down. The vehicle is legal. So what would we need a conditional dismissal for? Granted, based upon the allegations that were made in the complaint, we filed a answer and an amended answer and asked for a jury because he didn't want to waive his rights. But I recognize this is probably not a jury case at this point. So
I am so glad. And you know what? There are attorneys with much less experience than you that would have been coming in wanting a jury. And
no.
Yeah, no,
he just didn't want to waive his rights. So
right, I understand.
I agreed to at least do it up.
So what would be the necessity or the need for a conditional order dismissal?
Make sure that the grass and weeds get cut down. And if it's counsel can't testify, but counsel is stating that this is the vehicle he drove to your office.
Well, that's what I've been told.
So you don't know.
I didn't go out there. He told me he drove that vehicle to my office. He could if you want him to swear to it, I guess.
But that,
If it's an inoperable vehicle, it is not allowed to be on the property.
right, but you're gonna have to define inoperable,
Not
Be-
drivable, as in,
but that's drivable.
not according.
Well, I don't know if it's legal, but it looks drivable to me. You know what I mean? I mean, there's a difference between, do you have all the necessary equipment to drive it as opposed to like a headlight?
So he signed a document saying, please be informed my vehicle, the Nissan, is legally licensed and operable. I mean, he's willing to even testify to that or swear to it that this is. I mean, so it doesn't appear to be in violation, assuming those two factors are true.
Mr. Lacy, how would you, I mean, I guess we'd have to agree, first of all, upon a definition of operable
I mean,
as opposed.
legally operable, I guess, would be the definition we'd be looking for. Because if he were to take this vehicle out and drive it at night.
Right, but if he drove it during the day, there's not going to be an issue.
I think
Presumably.
we're supposed to have a front bumper. Taking me back to my Defender days with.
I looked at this, I'm like, there's no bumper on it?
No, there's no front bumper.
Well, you just don't hear anything.
Well, he's prepared to say he drove it to my office yesterday.
You drove that vehicle to Mr. Stringer's office yesterday?
Yes. Yes. The problem is, how to say that? Bumper was broken. It's minor broken. It couldn't, so I removed the bumper because it's not too well attached. There is a problem of headlight glass. Headlight itself is still working. And what I need a car is just grocery shopping every other day or something at the daytime. So this is, by the way, frame is okay, steering is okay, wheel, tire, everything okay, and engine is okay, of course. It's just headlamp glass was broken. Headlamp itself still works, and bumper is intentionally removed because it's well attached. I'm going to fix those because it's still operable.
Okay, so how long will it take you to fix that car and get those weeds down?
Means time?
Yeah, how long?
How long?
I don't know. Because I don't want to bring to the dealer because they will use new part which costs so much. So I have to go to junkyard to get the same one. Can I find the same parts within 1 month? I can't promise, but it's drivable anyway.
Can you mow the lawn in the next week? Can you mow the lawn in the next week?
Yeah, I'm doing.
You can mow those weeds in the next week.
Yes.
The weeds can be mowed in the next week.
And
We're willing to enter a conditional dismissal where the resident cuts the grass, weeds, flowers, whatever is along that property line within the week and agrees to not keep any inoperable vehicles in his driveway. So we will concede that the vehicle, while it may look like it's not operable, according to his testimony, it is operable. But if it does become inoperable.
So what's Lacey got against hoopties? No. I'm sorry.
I mean, the case would go away and we would dismiss it and that would work.
Well, yeah, so here's what I think. What's this one? This is, okay, so. What I might suggest is a conditional dismissal for a period of 7 months with those terms, not a whole year.
Okay.
But just to, really what would be almost the first cutting of something that he's going to maintain that and then call it a day.
Well, I guess the question is, if he goes and mows it right now, let's say he gets it done in the next week, so that issue is resolved.
The issue isn't how quickly it can be resolved. The issue is the fact that we had to come here with the issue.
Yeah, I mean, and that's why I was suggesting that period of time, because what I'm thinking of is get it taken down now. Then through the spring, just make sure that he's maintaining it. I mean, I don't think every year he'd be coming in trying to deal with it, but if you get the first cut and then the cuts after that, easier. I think it's the problem is going to be is that if he doesn't cut it in the first place, then it becomes much more difficult as the season goes on. So that's why I was suggesting that. But I mean, I appreciate both points, but.
I agree to the 7 month term. I think that's.
Do you agree?
I want to speak something.
Okay.
I want to separate a vehicle repairing and lawn or ground thing, because grass is growing and weed is sometimes growing. So I always maintain grass cutting always. My question is how I can prove next 7 months.
Well, you don't have to prove it. You will just, the only thing that has to be shown to the landlord is that you get it cut down now. And then when it starts to grow back in the spring, that you maintain it. But you don't have to prove that. They would have to prove that you're not doing it.
Right. So I don't think that is a new condition. It's just the same as before, same as now.
And that's the problem, Your Honor, that we have to come here because he allows it to get out of hand for so long. And now he's like, well, I can cut it. And I don't know why I have to be here or get a conditional dismissal because I can cut it and it's gone. But the fact that we had to file the case to address the issue after we've sent him notice after notice is the reason why we need the conditional dismissal with the terms. If he had come to this realization before, we had to file the case.
Folks, I've listened to everything. There's not really particularly an issue for me to try. What I'm going to do is I'm going to just order a conditional order of dismissal for a period that goes through May, if I counted my month right, May 31st. That he will not keep inoperable vehicles and will maintain the lawn area.
Thank you.
I'm just going to order it. If plaintiff believes that there's a violation, then it would be a 4A where there would have to be a hearing so that they can't just file a judgment and do that. Okay?
Understand?
So
this will be dismissed. as of May 31st.
Well, it'd be permanently dismissed as of May 31st. It actually is conditionally dismissed the moment I sign the order of conditional
So
dismissal.
it's conditionally dismissed now, but you have these terms and conditions. You have maintain operable vehicles on your property, and you have to cut the yard in that area where the weeds are. Yeah.
Okay, all right. So I'll look forward to the paperwork, and I'll just mark this file as conditionally dismissed along those terms. You guys can work it out.
Thank you, Your Honor.
So when are we supposed to be here for the jury, Your Honor?
Yeah, 2028.
Good seeing you again, Your Honor.
Good seeing you, Mr. Stringer. Always a pleasure, sir. Court does call the case of the people versus Milton Reyes. I have on case ending in 3664, I have a dismissal on that one. Ms. Lacy?
Oh, I'm sorry.
You just,
You're correct. That is dismissed.
well, the one case is dismissed. I have a dismissal on 3664.